Good afternoon. Welcome to the Appellate Division, First Department, and Happy New Year to those of you who are here for the first time this year. We have some 6 hours of argument time that has been requested, so please bear that in mind as I call the calendar and you ask for the time. Please ask for time that you absolutely need. Remember, we have your briefs, we have the record, and we're fully familiar with the facts of the case. Hudson Valley versus Rotron Incorporated.
10 minutes, 2 minutes to rebuttal now.
Do 5, 2, and 5. Thank you. Nadine C. versus Keith S. is submitted. Ramos versus City of New York. 5, 2, and 5. Thank you. Condo versus Condo. 5, 2, and 5. Thank you. Juice versus PPC Residential. The appellant first, please.
We believe that the appellant is not present, Your Honor, and has requested to submit. That is our understanding from electronic.
Okay. Do you wish to submit then?
Should the court have no questions, we would submit.
Is that true for you too? Okay, thank you. It'll be a submission then. People versus Junior Guzman. 6, 2, and 6. Syndicate Media versus Comtex News. 5, 2, and 5. Thank you. Brown versus New York Design. I can't see. Is there a respondent there? Do you wish to argue?
I would, yes.
Okay. I'll give you 3 minutes and a submission. People versus Yellington Concepcion. Submitted. People versus Lamar Davenport. 7, 2, and 6. Epic versus Epic W West 14 LLC versus Malta.
7 and 3, please.
Is there anyone else? Okay. So do you wish to submit? I beg your pardon?
I would like to argue.
Okay, I'll give you 3 minutes and a submission. I'm sorry, did you say you were the appellant or respondent? You're the appellant. Okay. Mayor Estates versus Century 21. 7 and 3 and 6. People versus Anonymous. 6, 2, and 6. Klingerman versus Ali. 7, 3, and 7. Kwong versus Zhu. Submitted. Berrio versus the City of New York. Submitted. First case for argument is Hudson Valley versus Rotron Incorporated.
Good afternoon, Your Honor. May it please the court, my name is Robert Sullivan. I represent the plaintiff appellant, Hudson Valley Window Cleaning. Before the court this afternoon is really 2 simple issues. First of all, whether or not a notice to cure provision in the contract between the parties is vague and is clear and unambiguous, and whether or not the defendant respondent complied with that notice and cure provision. The court below found that there was a disagreement by the parties as to the meaning of the notice and cure provision. With respect to Hudson Valley, we submit that the notice and cure provision provides a condition precedent, 30 days notice of defects in performance, and if those defects...
So there was a claim here that the performance was defective. Are there issues of fact with respect to performance that would be sufficient to deny summary judgment?
No, Judge, there are
So
no...
what did you do within those 30 days? When you get a notice saying we're not happy with your work, there are emails sent out, for example, pointing out deficiencies, what was done?
Well, Judge, with respect to the 30 days and the deficiencies, it was very general reference to the scope of work. There wasn't a specification as to what, which is really the purpose of a notice and cure provision, to enable the defects to be...
Wasn't there an email accompanying the notice that clarified what needed to be done?
Not with respect to the original notice, Your Honor. It made reference to the scope of work attached to the notice. The only specification of defects came later in the August 26th.
Well, is there anything in the contract that specifies how detailed this notice has, the specification about what you have to improve has to be done? Is there any?
There's nothing in the notice of cure that says how specific it has to be.
How specific it has to be.
There has to be notification of the defects.
So then why wasn't the email with the clarification informing of more specifics, why wasn't that sufficient?
Well, Judge, even if, assuming that's correct, that the notice was sufficient, the dispute as to the meaning of the provision between the parties. Hudson Valley submits that there requires 30 days notice, and then that triggers the 60-day termination. The respondent says, oh, no, that 60-day termination clause includes that 30-day cure period. So even if the initial notice of defects were sufficient, which we do not concede they were.
So you're saying there are questions of fact here?
Oh, no, Judge. I say that there is, no matter how you interpret the termination provision, they didn't comply with it anyway.
But what about the August 20th? I'm looking at the August 20th email that states that your services are falling short of expectations. If the service does not improve in its entirety in the next 30 days, our agreement will be considered null and void.
That's the August 26th, Judge. But the August 26th notice terminated the contract effective August 20th.
Well, they attached the August 20th notice of termination to that August 26th, right?
Well, what they did is they attached a series of...
Please find attached a notice of termination commencing on August 20th, 2021.
That's correct, Judge. It's still terminated prematurely. Even if the original July 20th notice was sufficient or the July 26th, either way, they terminated only 30 days after the July 20th.
So what would the remedy be under those circumstances if the termination was premature, say, for example? I mean, I think it's 37 days. It wasn't the full 60 days. I mean, there's no dispute about that. What would be the damages? You'd be entitled to the entire contract damages, or would it be limited?
We would argue they're entitled to the entire contract damage.
So in other words, you get a notice to cure. There's some question as to whether you cured or not. Because the termination is, I guess, ineffective, that would entitle you to the damages for the entire, was it a 5-year contract?
That's a breach of the contract, Your Honor.
Okay.
And we submit that that notice of termination should be enforced as written.
Thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court, my name is Jocelyn Lupetin from Cullen and Dyckman. I represent the respondent, Rotron. First and foremost, it's really important to note that this motion was made before any discovery was exchanged. We issued discovery demands, we issued a follow-up letter, they ignored that and filed a motion for summary judgment anyway, attempting to steamroll their way to a judgment on the issue of liability. However, there are issues of fact. The council even basically referenced them and even acknowledges them in their papers. They acknowledge the fact that there is no agreement as to, or a meeting of the minds as to what the termination period is. Is the 30 days inclusive in the 60 days? Is it a 90-day period? But regardless, it's our position that not only is that an issue of fact, I think that counsel would argue that there is an issue of fact as to whether our initial notice of July 20th complied with the provision. We believe that it did. And then what happens after that is that what happens here that, counsel is arguing that the court here should, review this issue de novo. If they do that, you can see that there's an inherent question as to what the provision means. So at that point, we look to the actions of the parties or any extrinsic, evidence that may be available. And at this time, it's only the actions of the parties. Now, Hudson Valley, following the July 20th 30-day cure notice, performed for 30 days and then stopped coming. They made no effort to cure the deficiencies that were outlined in the email that were attached to the July 20th
So that's your
notice.
argument that they abandoned the performance, right?
Yeah, it is. And that, they stopped showing up July 20th. And I will point out that in the reply brief, there's a misstatement and a misreference to the record that I just want to point out. They did not come until August 26th. That is not accurate. There's nothing in the record that shows that. The reference to that in the record is not accurate. So I just want to make it clear, they stopped coming on August 20th. We then issued the second letter confirming that the contract was terminated on August 26th.
So you would agree, wouldn't you, that you really only gave 37 days of notice, right?
I would not agree.
Just
We
do the
gave-
math. It is 37 days. So the question to you is this, let's assume that the notice of termination was not valid.
Mm-hmm.
Would the plaintiff under those circumstances be entitled to breach a contract for the entire 5-year period?
Absolutely not. But I would argue that counsel made it very clear that he wasn't seeking that issue, wasn't seeking to determine that issue on this motion, but we strenuously disagree with that interpretation, that they would be entitled to the hundreds of thousands of dollars that they think that they're entitled to should we have been found to have issued an improper notice of termination. But again, I would go back and say, we gave them 30 days to cure. They failed to do that, and then they just stopped coming. There was no attempt to remedy the deficiencies or do anything else to, they did not act properly. Perhaps my client could have done a better job, but they certainly did not do what they were supposed to do.
Perhaps your client could have done a better job at providing a notice with the additional 30 days, you're saying, or in being more specific as to what the issue was in the first place that they had to cure?
I mean, I think that our notice is sufficient. I mean, as I believe the court kind of pointed out in a question to counsel previously, there's nothing in that provision that states specifically how those notices and how what needs to be cured is to be specified in that notice. We pointed out the fact, and the lower court even pointed it out in the decision, that there was a reference to the fact that they were falling short on all of the ways they performed. And there's tons of evidence that we have now been able to, demonstrate, which isn't relevant here today, but there's additional discovery that needs to happen. We have depositions that need to occur, and I would just like to point out that there's no prejudice to the appellant if we're able to just continue and pursue this discovery and sort out these issues of fact, because he only sought summary judgment on the issue of liability. We continue along with discovery no matter what on the issue of the damages. So, there's not going to be any other time or money expended. That will already have to have been done. The only prejudice would be to my client if we're not allowed to, exchange the proper discovery, seek the depositions, which are scheduled in time to, properly handle this. And then, hey, counsel can make a new motion for summary judgment once that information has been provided and my client has had an opportunity to obtain the information that we believe we are entitled to and which would resolve these issues of fact.
Thank you.
Thank you very much.
We reserved 2 minutes for rebuttal, but I'll wait back.
Okay, thank you very much. Thank you both. Ramos versus the City of New York.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant. As you know from reading our briefs, our position is that summary judgment should have been denied because the city did not rule out as a matter of law all of the substantive elements of the defense that they had to. And to be more specific,
What precisely, Mr. Isaacs, is your claim here?
I'm sorry, Judge,
What's
I
your
missed the last
claim
part.
here? What is your claim?
The claim is that the path that the plaintiff fell on was a defective condition.
Okay, is there written notice of that?
There's no written notice at all. So
Okay.
what we're claiming is that under the San Marcos case and its progeny, the creation of the path in an area where the mulch and the dirt could actually accumulate was a defective condition that made the area more dangerous, taking the matter out of the written notice claim. And I would point out to
Was
you,
that theory raised in the notice of claim? Was your theory that it was a cause and create, essentially, was that raised in the notice of claim?
yes, actually it was. Take a look at page 34, if you will. It's actually there's the ice condition. Let me give you the pages, Judge. 34, paragraph 2. There's an entire sentence about the weather conditions, the ice being present, and there's a specific reference, and I'm quoting now, to ice which covered the visible presence of rocks. If you carry over, there's nothing in the complaint, but in the BP, paragraph 50, page 55, paragraph 19, affirmative creation claim causing, allowing, permitting the premises to be defective in quote, creating an excessively slippery substance thereon.
I'm sorry, are you reading from your bill of particulars or from the notice of claim?
Notice of claims on 34, bill of particulars is on 55.
Oh, what are you reading from, the notice of claim or the bill of particulars?
I read the first part was from the notice of claim. Second
Anything
part
in the
was from
notice
bill
of claim
particulars.
saying any reference to creating a condition?
Well, it says, on the top paragraph, it says causing, permitting, and allowing said premises to become dangerous, remain dangerous, et cetera.
Right, that was a catch-all. You said that due to the city's negligence in failing to maintain Macombs Dam Park in a reasonably safe condition. But you didn't specifically state as to what that dangerous condition was.
Well, I think I think you have to read, Judge Weber, if I can. You read the first, not the first paragraph, but the first part of 34 with the second, and that's the specific reference to the
Well,
ice
she
condition.
says that, I mean, the notice of claim is that she slipped, tripped, and fell on debris that the city negligently had allowed to come through the fencing and remain on the pedestrian walkway.
So, I mean, but we know that in a notice of claim, you don't have to plead the cause of action the same as you do in haec verba because it has to be served within 90 days. That's what the court said in the Skogda.
But doesn't, the notice of claim has to give notice to the city as to exactly what the claim is. Are you claiming that she slipped and fell on the debris, or are you claiming that she slipped and fell on ice buildup?
Well, I think what happened, and one of the points that we wanted to make was that the plaintiff's deposition testimony, and we're looking specifically at 84, 85, 97, and 99. What the plaintiff said, the trial court said that this is not a snow and ice case. Clearly, that's what the judge said, and that's what the city said. They said this is a case dealing with debris on a roadway within Macombs Dam Park, and since there's no prior notice, there's not a problem. I don't believe that that's what the plaintiff said.
I'm looking at her testimony on page 84. She says that she followed the other people.
Yep.
It must have tripped on, I guess, dirt, debris, or whatever. It's hard to explain. I guess it was debris or something. You know, some other explanation, mulch. I don't see, then she talks about mud, dirt, or rocks. I don't see anything here about ice.
Well, Judge Weber, if I can, so you're right on 85, line 2 now. I know exactly where you're reading from. Let me read the next question and answer if I can for you.
What page is that?
This on 85.
Okay.
85, line 3. Did you see this area before you tripped on it? Answer, the day of the accident. Question, that very day, yes. Answer, I didn't see the mulch or anything of the sort. That's just when I fell down. That's everything that was on my hands. If you go to 97 to 99 of the record, you'll see that the plaintiff's testimony was that there was a 3-foot path that was created by the city, shoveled. It was originally clear, and she said that that mulch, that dirt, those rocks existed for 10 feet straight in the path.
She said the debris was actually this whole area, the whole area, I want to say about 10 feet long.
Correct.
Here to about 10 feet indicating.
Correct, and we have one other factor, which is the key factor in the case, obviously. I've got an eyewitness who has an affidavit. The affidavit's perfect, right? It's a Bronx DA. He comes on the scene afterward, he's the hero. He gets a cab, he goes with her to the hospital. He ends up saying that there's a slippery and ice condition right there. So I know that the plaintiff's testimony is a little off, but the testimony of the ADA, you have to take the best case scenario in a summary judgment motion, and we think that in this situation, the grant of summary judgment was inappropriate. Thanks.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for respondents.
I'd like you to start with the notice of claim issue, and I'd like to hear what your view is with regard to whether the plaintiff has indicated in the notice of claim this condition of ice.
Well, I think if you're talking about the condition of ice, yeah, I think there is ice itself is mentioned in the notice of claim. I think what I understood the initial questioning to be is whether the cause and create theory was put in the notice of claim, and I think as we've established during the previous questioning, it was not. I mean, had to go and link it up to the bill of particulars to find it. And on the preservation point, why I don't think it was preserved by not having it in the notice of claim, you don't even really need to grapple with that issue because they didn't argue it in the opposition to the summary judgment motion. I mean, they didn't preserve it there because we made a prima facie showing of lack of prior written notice, and the burden then shifted to them to establish, or at least a question of fact as to the existence of one of the two recognized exceptions to prior written notice, and they didn't do that at all. They didn't contest prior written notice.
So let's assume for a second that the theory is in there. Is that theory sufficient? Is it an affirmative act by the city that was committed, or is it a mere omission?
It's a mere omission, Your Honor. As I say, even if we get to the merits of it, they still haven't created a question of fact because they're talking about negligence. All their allegations are that they negligently.
So it's a failure to clear the path.
Correct. And there's nothing in the record or any testimony that could support an inference that somehow the clearing operations pushed, dirt or mulch or something onto the clear portion of the pathway. The only evidence is to the contrary. The plaintiff testified that she had seen it come through previously, that there was chicken wire fencing along that separated the pathway from ball fields, and dirt and debris would come through that fencing onto the pathway. And that's actually sort of how they pled it in the beginning. They made it a defective fencing claim. So there's no, I don't think you even get to the merits because the lack of preservation is so clear in this case. Even if you do, there's no question of fact that could support an affirmative act of negligence that would take this out of that would make an exception to prior written notice.
So just to be clear, are there witnesses? I mean, isn't there the witness who comes upon and to pick her up and take her to the hospital, and another witness, perhaps maybe it's the same one, who says there was ice, a slippery condition that was essentially caused by the way the ice is pushed up on one side?
No, the only thing that this affiant testified to was that there was half the path was snow and ice. He didn't say that it was because of that. And he also notably didn't say that he actually saw the plaintiff fall. And there's been a constant toggling between their theory of the mechanism of the fall here. They tried to argue that it was a snow and ice and she slipped on the snow and ice at summary judgment. Now, I mean, look at their appellate briefs. Now they're back to arguing that she fell on the dirt and mulch, which is what she testified to. I mean, you can't keep ping-ponging back and forth like that, because if she can't identify what she fell on, then that's another basis for summary judgment.
Thank you.
Thank you.
Sorry, so Judge Singh, in response to my adversary's claim, it's not a passive act, all right? If you look at 81, the plaintiff originally...
What's the affirmative act?
The act is shoveling the path. That's the act. That's an affirmative act. St. Marcos says if you shovel and you make the area more dangerous, that's an affirmative act. Whether you like it or not, that's what the court said there, because that was the melt and refreeze scenario. It's the same thing here. So I'm not saying that they didn't shovel. I'm not saying they had to do everything. All I'm saying is if you look at what the plaintiff said on 81, she said the path was shoveled. The witness the ADA specifically said he saw her fall, and he went to the area, there was ice there, and their witness, not my witness, their witness, 233 and 234, says that using the kind of chain link fence that you see in that scenario because of the presence of mulch, dirt, the gardening, was something that he didn't consider safe. On a summary judgment motion, I don't think that you lose the case summarily in that, and I would just ask you to look again at 34 and 55 of the pleadings. This was pled, and the city's assertion that it's not in the case is wrong. Read their motion. Point 5 or point 4 of their motion, point 4 or point 5 of their reply affirmation says, we did not affirmatively create an act. And in their brief, 3 times they say, hey, Mr. Isaac, you're stuck with the plaintiff's testimony because she didn't submit an affidavit. That's fair enough, I am. But if I'm stuck with the testimony, so are they. They have to refute the allegations in the pleadings, in the complaints. If they don't do it, I win because they don't meet their burden. That's my
Mr. Isaac, I'm sorry if this is redundant of something Judge Singh just asked you, but marshal for me, if you will, the evidence that the defective condition was affirmatively created
So the
by
plaintiff,
municipality.
so the plaintiff said she was in a path. The testimony of the Parks Department employee was that only the Parks Department employs that. 233 and 234 is their witness who says that this has happened in the past, and he would consider it to be a defective condition, that it's an unsafe practice to have those kind of fences in that area because the dirt, debris, and mulch can come in. And you have the testimony of the ADA who says he was behind her, he saw her, she slipped in a very slippery area. I agree that she did mention, as Judge Weber said on page 84 of the record, that she fell on mulch, debris, and stuff like that. But again, I think if you read page 85, she wasn't really sure what she fell on. She assumed that that's what she fell on because the substance was on her hand. One other thing, and I'll sit down.
Well, I'm sorry, doesn't that tie into your friend's last argument that if your client was unable to identify the cause of the fall, that would be a separate and independent basis for summary judgment?
She identified 2 causes of the fall, and we specifically cited to your seminal decision in Nehemias against Concourse Realty, which says that if there are 2 or more conditions which conjoin to create a defective condition, a defendant is liable for that accident if it's responsible for one of those conditions, even if it's not responsible to the other. That's 41 AD 2nd. Last point, you decided a case that's in our reply brief called Dees against MTA. I thought it was a seminal decision. It was a decision where you said that even though the expert testimony, that was Nick Belizzi, was contradictory to that of the plaintiff, the jury had the right to believe the expert and not the plaintiff. And in that case, you weren't dealing with summary judgment, you were dealing with a verdict. So I'd ask you to take a look at that case too. Thank you.
Thank you both. Condo versus condo.
Good afternoon, Your Honors. Anthony Ullman for Plaintiff Appellant. As this court has previously noted, the appointment order is fundamentally a contract. In New York law is clear that contractual provisions for an award of attorney's fees are to be narrowly construed, and that whereas here, fees are claimed under a contract, an intent to waive the American rule will not be inferred unless that intent is unmistakably clear from the contract language that is used. And those principles are dispositive here. Item 6 on page 3 of the appointment order authorizes a special master to award fees incurred as a party's assertion of a false or misleading claim or defense or failure to cooperate in the resolution of items 1 through 4 on page 2 of the appointment order. And those items 1 through 4 on page 2 are disputes on certain specific matters relating to the division of marital property that were to be overseen, resolved, and determined by the special master.
Aren't these issues that the special master looked at and decided that the plaintiff's misconduct warranted reallocution? Don't they fall into that category?
No, they don't, Your Honor. First of all, they weren't decided by the special master, which is what is required under item 6 and page 2 of the appointment order. And most of these had nothing to do with it. The disqualification of Mr. Beslow had nothing to do with the division of marital assets or any of those items.
Wouldn't that cause delay? I mean, consciously, it was an attempt to get the judge to to be recused? Wouldn't that result in delay and delay in distribution of marital assets?
No, Your Honor, there's no evidence in the record that the proceedings, first of all, would have to cause delay in the special master proceedings. If anything, there was delay at the court level, but there's no contention that the disqualification of Mr. Beslow caused any delay in any proceedings with support of the special master, which is where the failure to cooperate has to be evidenced and demonstrated.
What about the refusal to pay the special master? Does that, the refusal by your client to pay the special master?
Right, but the proceedings there, again, all occurred in court, and those proceedings were not items 1 through, those proceedings were not the resolution of items 1 through 4 on page 2 of the protective order. They were a separate issue that was decided not by the special master, but by the court, whether she had a right to payment, and the other issues that were on that motion. That has nothing to do, again, that's not the item, the resolution or determination of items 1 through 4 on page 2 of the appointment order by the special master, which is the only thing that the special master is authorized to award fees for under item 6 of the appointment order, and let alone is that authorized with the requisite unmistakable clarity that's required under this court's.
I thought we were talking about the awarding, two things, the awarding of the counsel fees, so the attorney's fees.
Yes.
And also the awarding of additional fees, right?
There was one item of professional fees that the special master awarded
To Ms. Solomon, right?
Laura Solomon.
Okay, so in terms of the attorney's fees, the issue was whether your client did not cooperate. And so when we're discussing her lack of cooperation, Justice Singh asked you in terms of delay. So one was the termination of the attorney. The other, was it not the fact that she refused to pay the special master?
Again, but that was a proceeding in the Supreme Court. That was not part of items 1 through 4.
Would that not lead to delay?
It could. There's no evidence that it did.
How about the multiple appeals taken by your client?
Those were taken in exercise of.
Well, could those appeals have also resulted in delay in distribution of marital assets?
There's absolutely no evidence that that's the case. In fact, the defendant has conceded that plaintiff continued to participate in the special master process while those appeals were pending. There is no evidence that the appeals caused any delay, and we've set out.
Counsel, you're reading, I think, those terms very narrowly. And if you read them more broadly, all of them lead to the conclusion of the distribution of marital assets. This wasn't completed until each one of these steps was done, was played through. So each time there was another appeal or there was another action or whatever it was, it delayed the ultimate distribution. I think it was fair for the special master to read it broadly as opposed to as narrowly as you're reading it.
Well, Your Honor, with respect, I don't think that's the applicable standard. The standard under the Hooper case is reaffirmed by the AMBAC case and more recently by the Sage Systems case, is that the intent to allow an award of attorney's fees has to be unmistakably clear. You can make arguments, as the other side has, that, gee, this should be read broadly, but I do not believe that you can look at the language of item 6 on page 3 of the appointment order and say that the intent to allow the special master to award attorney's fees in proceedings before the Supreme Court or before this court was unmistakably clear.
But wasn't the appointment order cast in broad terms? Prefatory language that said the SM has the authority to oversee, resolve, determine appropriate remedies for the following issues, then lays out the issues,
right,
but then doesn't condition those issues on being before the special master herself.
But that's where the item 6 comes in. It only comes in for a lack of cooperation in the resolution of items 1 through 4. Those items are determined by and only by the special master in proceedings before her.
But wouldn't it have been easy to put in that appointment order language that limited it to matters solely before the special master, as opposed to delegating broadly in protracted litigation where we're trying to find some efficiencies here in the resolution of these issues?
With respect, the standard, again, is unmistakably clear. There is nothing that indicates that the special master's powers extend to proceedings that are not before her. And we have looked, we have not found a single case in any reported decision anywhere in the United States where a special master was authorized to award fees in proceedings before court. That's not a natural reading, and it certainly is not a reading that is unmistakably clear from the language that was used in item 6.
But certainly an attempt to remove the special master would be clearly an attempt to delay the proceedings.
But again, it wasn't within the scope of item 6 because that was not part of the proceedings before the special master that she was resolving and determining as set forth on page 4. I'm sorry, page 2 of the appointment order.
Thank you.
Thank you.
Good afternoon, Your Honors. I'm Sheila Ginsburg Grizel of the law firm of Blank Rome, representing the respondent, George Kondo. In the 6 years so far of the post-judgment litigation in this 9-year-long divorce action, 2 Supreme Court justices and the special master, based in part on the decisions of this court in 3 prior appeals by the appellant, found that the overwhelming portion of the post-judgment litigation has been caused by appellant's, quote unquote, by Judge Cooper, bad acts.
I'm sorry, ma'am, just to stop you here on a sort of a threshold issue. Much of the relief you're seeking, the monetary relief you're seeking, rises or falls on whether the purported delay occurred before the special master herself or occurred in the course of the litigation before Supreme Court. So would you mind addressing that point about the reading we ought to give to the appointment order and the special master's powers thereunder?
Absolutely, Your Honor. As was conceded by my opponent, the special master derives her authority from the May 8th, 2017 special master order that was first stipulated and then so ordered by the court. The language of the special master order provides in pertinent part that Susan Bender, the special master, could determine any award of counsel fees and professional fees to a party as a result of the other party's assertion of a false or misleading claim or defense, or the failure to cooperate in the resolutions of Romanet 1 through 4 set out in the special master order. Romanet 1 provides that disputes arising between the parties regarding the division of marital art. I believe, as Your Honor earlier pointed out, there is no exclusion or no requirement that the failure to cooperate had to be in a proceeding before the special master. In point of fact, there's no reference to excluding the conduct before the court. If the parties had intended to do that, they could have done that, but by inserting a provision in the special master order.
And I'm sorry, ma'am, is there any tension between your reading of the appointment order and your friend's argument that under Hooper, these arrangements have to be given a strict construction?
Well, I believe that looking at the specific language of the special master order supports our interpretation of the authority that was provided by the language. Each of the instances in which the fees were awarded exemplify appellant's failure to cooperate in the resolution of disputes between the parties regarding the division of marital art. In point of fact, where there is no effort to cite where that conduct must occur, and the special master was governed by the findings of the Supreme Court and this court that the issues and actions by the appellant had no basis in law or fact, and the specific findings of Justice Cooper that they were designed to delay the process. The special master defines what lack of cooperation was the criteria that were to establish a lack of cooperation. And she makes quite clear that it's the intention to delay, not the actual delay, although one might look at the 6 years at which we have been litigating this and find that it establishes that she was quite successful in accomplishing her
Counsel,
goals.
what do you say about the proposition that the plaintiff here is being punished for pursuing actions that she was entitled to pursue?
I'm sorry, Your
I'm
Honor.
sorry. What do you say to the proposition that the plaintiff here is being punished for pursuing actions that she was entitled to pursue?
I don't think that has come into play at all, because when one looks at the quality of the issues that plaintiff has raised time and again, there is no justification for what amounts, I believe, to an abuse of the court system and certainly an abuse of this respondent. For example, one of the actions upon which fees were granted was the appellant's retention of William Beslow, knowing in advance of her retention that to do that would require the automatic recusal of the judge who was presiding over this entire case and had done so for 4 years, simply by retaining him. And in point of fact, it required us to move to disqualify Mr. Beslow, and the special master granted us fees for our efforts in doing that. And as was earlier pointed out, she then sought to get rid of the special master because she didn't like the special master's rulings. And a year and a half into the process, having stipulated to the appointment of the special master, she then refused to pay the special master, claiming bogusly initially that the request for payments were premature, and then claiming at one point that she didn't have the funds to pay the special master, and then claiming that the special master was biased in seeking to be paid the fees that were pursuant to court order.
Thank you.
The issues here are simply a matter of construction of the language on page 6 of the appointment order. With respect to Mr. Beslow, there has never been a finding that there was an intent, that she hired him with an intent.
So I don't know, it seems pretty clear. Why would she hire Beslow where the judge has filed a complaint against the attorney? I'm sure Mr. Beslow advised the client, and she nevertheless...
Well, at the time, our firm had introduced plaintiff to Mr. Beslow as a replacement lawyer for Prior Cashman.
Counsel, I think I was on that panel, if I'm not mistaken. And I thought that the record was a little bit different than what you're stating. I thought that she was aware of the fact that there had been a disciplinary, if I'm not mistaken, that there was an issue with Justice Cooper and Mr. Beslow in terms of a disciplinary issue.
No, absolutely, no, she was aware. Mr. Beslow had told her that, but she made a decision that she still...
Knowing full well that therefore that would require, under the ethics rules, Judge Cooper to have to recuse.
Yes, but there's nothing improper.
Yes, well, yes.
There was nothing, but...
I think there is, well, I
Justice
think our
Katz-
determination, if I'm not mistaken, our determination in that case was that there was something improper. But again, counsel, if we can go back to the appointment order, what you're looking at, it seems to say anything that would relate to the distribution of the marital assets.
No, it specifically says the resolution of the items on page 1 through page 2, items 1 through 4, all of which are
Disputes
determined.
arising between the parties regarding the division of the marital art
Right, but
pursuant to the terms
right.
of the agreement.
All as are determined, overseen, and resolved by the special master. The word relating to, in some sense, doesn't appear there. I mean, basically, the standard is unmistakable clarity. And the very fact that, in fact, that we're having this discussion, that you think, there may be a reading that's broad versus one that's narrow, shows that the unmistakable standard is not met. The last thing I'd like to point out is if for some reason the fees awards are not vacated for this reason in their entirety, the fees evidence that was presented below is entirely insufficient to support it. The amount, there is no way to tell from the amounts that were put in or the affidavit of Ms. Rizel what the fees were, how you calculated them, or whether the time entries tied to them, the special master refused to allow a hearing. So in all events,
Does the appointment order call for a hearing under such circumstances?
the law does, Your Honor. The appointment order doesn't, but it doesn't need to. I believe the law is...
Counsel, aren't we bound by the appointment order?
Of course, it's a contract, Your Honor.
And shouldn't we look at the discretionary decisions made by the special master in rendering her decision?
You should, Your Honor, the law is clear, I believe, that when a contract provides for an award of attorney's fees, unless it is absolutely 100% clear in limited circumstances with an appropriate affidavit that the fees are properly calculated, the trier of fact on that has to hold a hearing. That's the Cumble case and other cases that we cited in our brief.
Thank you.
Thank you.
Thank you both. People versus Junior Guzman.
Good afternoon, Your Honors. Elizabeth Caldwell from the Center for Appellate Litigation on behalf of Mr. Guzman. May it please the Court. I plan to address the unavailability of the complaining witness today. The prosecution here failed to establish that it had exercised due diligence to find the complaining witness, as Penal Law Section 67010 requires. And the trial court therefore erred by deeming that witness unavailable. The Court of Appeals has repeatedly emphasized that admitting the transcript testimony of an unavailable witness should only be done as a last resort and when the statutory requirements have been strictly met. The prosecution here failed to meet that exacting standard based on its limited...
Does the statute require a hearing under the circumstances? Is there anything in the statute about that?
The statute also requires that there be a hearing.
Does it state explicitly that a hearing is necessary?
Yes, it does, Your Honor. In provision 670.20, the language, and I can quote it for the court, is that in determining the motion, the court, with opportunity for both parties to be heard, must make inquiry and conduct a hearing to determine whether personal attendance of the witness is so precluded.
Is there a definition of hearing? Does it define what constitutes a hearing?
The statute itself does not, but there are many cases from this court and from the Court of Appeals that contemplate that a hearing includes calling witnesses and actually hearing them testify about...
And there are other cases that talk about you don't have to call witnesses, there would simply be an inquiry of the, in this case, of the people. Is that correct?
No, Your Honor. The cases on which the prosecution relies for that point don't actually contemplate what kind of hearing is required by 670.20. In both of those cases, I can look up the names, the parties had actually stipulated that the witnesses were unavailable. So any reference to what hearing was required wasn't being disputed in those cases that the prosecution cites.
And so in the cases that you're citing, what case is that?
In going back to People versus Arroyo in the early 1980s, the Court of Appeals talks about the fact that there was a hearing on which the detective testified about all that he had done. The ADA testified about all they had done to find a witness. And it was on that record that a proper unavailability finding was made.
In Arroyo, the court, I thought, made an inquiry of the people as to exactly what had occurred. Is that correct?
That's correct, and that was done through a testimony of witnesses.
Sworn testimony?
That's my understanding based on the record there. It says that there was a hearing where the ADA was called and testified, that there was evidence presented, things along those lines. So I do believe those cases support the proposition that hearing in this statute requires.
Well, I'm looking at Arroyo. I don't see anything in the case that talks about sworn testimony.
I can respond to that on rebuttal if that's okay, Your Honor, in terms of the particular language. I mean, I can say that recently in this case, in this court's case, People versus Bailey, again, this hasn't been decided, but there's reference to the fact this is commonly occurring, which would support the idea that this statutory provision does actually require a hearing.
And just to go back to the statutory hearing, it speaks, I believe, to an opportunity to be heard, give parties an opportunity to be heard, and then uses the word "and."
Correct, Your Honor. That's right. So there are two things here. The statute contemplates an opportunity to be heard, and that there is a hearing. And
Was
here,
this issue preserved, counsel? Was this raised below that a hearing was mandated under the circumstances? Anything like that to the judge?
defense counsel did not specifically request a hearing, though he vehemently objected to the adequacy of the procedures that had taken place here. So there was, the court was on notice that there was a dispute as to the factual determination of whether there had been actually a sufficient inquiry to find the complaining witness here.
So had the objection been raised at the right juncture, the prosecutor could have been sworn and then provided his or her narrative of the efforts that were made. And that would have satisfied by the definition of your giving the word hearing in the statute, that would have satisfied your argument then.
That's correct, Your Honor. In terms of actually what was presented here, the efforts made by the prosecution to find this witness, they were really quite limited. The prosecution said that they had tried to call the phone number that they had previously used to contact the complainant, and they made no contact. And otherwise, they just asked the detective on the case, quote, who he had seen and what he had heard of the complainant. This fell far short of the standard.
Isn't there more than that? The people also said that they never had an address for the witness. They also said that their communication with him was limited through his girlfriend, and then she had somehow become unavailable as well. So it's just more than just the way you put it, just making a phone call and not receiving a response.
So the phone call was to the complainant's girlfriend, to clarify. In terms of the address, that's right, that's the proffer that the prosecution made, but
Wasn't
actually—
there some, sorry, but in addition to the in addition to the address, wasn't there something then in response to that, that there was, he sells drugs at a particular street, and I think that the prosecutor addressed that to the detective.
If I may respond.
Yes,
yes,
please.
The detective said, or the prosecution said, well, the detective told me he hadn't seen him. But there was no representation that the prosecution had actually contacted, for instance, all of the numerous agencies that had been supervising this complaining witness.
Well, that was the other thing, because he was incarcerated at some point in time, was he not?
That's correct. He had been
And then
incarcerated.
he was released to ICE custody, to ICE, is that correct?
That's right. He was in ICE's custody, and there was no representation. So there was one representation with respect to the immigration attorney who said, oh, he doesn't have any more court dates. But there was no representation that didn't mean that ICE had no way of contacting this person, or that there was no address or phone number for him.
But I thought he was in their custody.
He had been in their custody, and then he was released prior to Mr. Guzman's trial. So that was part of the issue, was he was no longer in custody, and that's when the prosecution said, oh, we can't find him now. But there was no—
Who was it who made the statement about, yeah, this is where he is, at the corner of whatever? Who was that who made that statement?
Defense counsel had given kind of that tip that he had heard that the complainant—
In other words, defense counsel nor anyone else had an idea of where his address was. Even through contact of the girlfriend. That's why they suggested that street corner.
I'm sorry, can you repeat that?
I said neither defense counsel nor anyone else had an address for where this individual was. That's why it finally evolved into the street corner.
Right, so defense counsel did not say that he had any address, though I will point out the medical records that were actually introduced into evidence in this case included an address that the complainant had given on the day he was actually treated. So there was some evidence that there was an address out there. And again, this is someone who had been under the supervision of the Department of Corrections, the New York City Department of Corrections, the State Department of Corrections. He had repeatedly been in contact with the criminal justice system.
Also, the fact that the complaining witness refused to testify, how does that play into this?
Your Honor, two responses to that. The first is that the complainant did refuse to testify one time, but there had been a long history of cooperation for over 2 years.
Right, but the lower court at that point concluded that the complaining witness was unavailable because he refused to testify. Isn't that right?
In a prior proceeding, yes, Your Honor. But I would point out, so if I may just lay out the timeline.
Yes, please.
So this incident happened in the fall of 2014. Within a month, the complainant testified he was in immigration custody. It was during his time in immigration custody that he began cooperating with the prosecution. That was February of 2015 when he testified 2 times before the grand jury. A year goes by. There's the first trial at which he testifies. Then another year goes by, and that's when Mr. Guzman's co-defendant had his second trial. It was only at that point, so over 2 years after his initial cooperation, that the complainant refused to testify in this one proceeding. And at that point, a judge said, on that basis, I'm going to make a finding that he's unavailable. Shortly after the trial, he is released from ICE custody, and several months go by. And at this point, the prosecution says, well, we no longer can find him because he's no longer in custody. But the prosecution, the basis for the prosecution's initial application to the court in this case was that, oh, he had previously been so uncooperative, that's why you should find him unavailable in Mr. Guzman's second trial. But the court didn't make its ruling on that basis. Instead, the court said they've taken reasonable steps to locate him based on calling this previous phone number that they had and saying that they don't have an address. But again, there is an address that's in the record here. This person had numerous contacts with the criminal justice system, and this person was subject to a final order of deportation. By federal law, he would be required to provide up-to-date information about his location so that the immigration authorities could carry that order out eventually. So this was a case where there were other common sense avenues for the police to try to find this witness, but they didn't take them. There was no opportunity for that to be fully fleshed out in a hearing, and the result of that was—
I beg to differ. That's the rub. Had these arguments, as my colleague pointed out, had these arguments been made below, they would have been fleshed out at that time, no?
Well, I think putting aside the question of whether a hearing was required, what we have here is a record on which the trial court made a finding, and our argument is that on the record that was developed, putting aside whether there should have been more development of it, there's not a sufficient showing here that the prosecution exercised due diligence in trying to find this witness. And keep in mind, this is a person who was heavily impeached by the defense in the first trial. This is someone that the prosecution conceded in summation to this jury was not someone they would want to believe. He was, this was someone that was not very—
So in other words, what you're saying is that the prosecution really wasn't relying on Leon's testimony, it's on all the other evidence, so wouldn't there be a fair argument to be made that it was harmless error?
Right, because there was also surveillance video, which was the other issue, is that you really didn't need Mr. Leon, right? Because there was surveillance video of the incident, and you had the medical record. So would there not also be a harmless error analysis?
If I may continue, Your Honors, there are 3 reasons that this is not a harmless error. For one, this testimony, the prosecution says, well, we never read it aloud to the jury. But the defense counsel read extensively from the complainant's testimony at the trial. If you look at the record, it's about 100 pages of the transcript is defense counsel reading aloud this testimony to the jury. And the content of that testimony was very important to the justification defense that the jury was charged with. At least 4 times in the course of the complainant's testimony, just what was read aloud, he denied having any weapons on him on the day of this incident. He also said, oh, I didn't actually injure Mr. Guzman's leg, which was part of the defense counsel's argument about justification. So these were important statements, and they contradicted the defense witness.
But
who
again,
actually-
I thought the video surveillance showed that Mr. Leon had a bat. Wasn't it depicted in the video that he actually had a weapon?
well, there's
That he had a bat, right?
so he says basically, oh, I didn't have a knife, I didn't have a gun, things like that. He says, you know, I
But
picked up.
it depicts him with the bat, and I thought he also smashed the window, the
That's-
vehicle's window with the bat.
So he has a golf club, and he says he's going
Golf
toward.
club, sorry.
Yes, Your Honor. So he's going toward Mr. Guzman with a golf club, then smashes this window right next to him. But the defense had presented a witness who said there was actually a gun on the scene of this crime. So we have here testimony from a defense witness saying that someone, an associate of the complainant, called out for a gun at some point. We have contradictory statements from the complainant that are read aloud to the jury that bear on whether or not he actually had a gun or did not have a gun. So all of this is to say this testimony was presented to the jury, and it bore on whether or not the defense or the prosecution could disprove beyond a reasonable doubt the justification charge. In addition to that, both parties were drawing on this testimony in their summation. Defense was arguing that there was a credibility determination for the jury to make about whether to believe the defense witness who was saying the complainant had a gun versus the complainant who was saying, you know, I was.
Anything on the videotape that showed a gun, anything like that might be helpful to the jury to resolve that issue?
There's, you know, it's not. There's someone who's walking around behind the complainant who has something in his hand. It's not clear enough to be able to say what it is. But the video doesn't have, you know, you can't hear all of the threats that are being made back and forth between these parties on the video, which is another thing that the complainant testified about.
And Leon was on the ground at this point, right? He was being cut with the box cutter or something like that?
The complainant had slipped on the ground, but that was after he had run toward Mr. Guzman with this golf club and then swung into a car right next to him. So all of this is to say this evidence was before the jury, and that there's at least a reasonable possibility that these statements from the complainant, for which there was no other evidence that sufficiently there was no other evidence on which the jury could rely about these statements, like whether there was a gun or not. So there's some possibility that that testimony from the complainant did bear on the jury's determination that justification had been disproven beyond a reasonable doubt.
Thank you.
Thank you, Your Honors. Thank you for the additional time.
Good afternoon, Your Honors. May it please the Court, Jared Walkowitz for the people.
Counsel, what about your adversary's position that, you know, the people did have other information? They had the address and the medical records. They could have asked ICE for contact information. What about that?
Well, a few things. First, we did not have a working address for him at the time of this hearing. That's clear from the record. Whether there's an address for him pre-ICE in the medical records, that again was never brought up by counsel. So obviously the parties both understood, because of the context of the argument, that there was no address for him at that time. The prosecutor even said at the hearing, we had no address for him before he went into custody, and we have no address for him now. We have less information. I think his exact words were, we have less information for him now. So to the extent that there may be an address he gave to the hospital, obviously they're coming at this with a history by the time 3 years later in the third trial, and that is not an address that anybody at that point is disputing was a valid address.
But you knew he had been in ICE custody.
Yes.
Is that correct?
Yes.
So, and he had been released from ICE custody, Is that correct?
That's correct.
So, as your adversary mentioned, he would then have to report to ICE, et cetera, and there would have to be a working address for him.
Again,
for him. So did you check to see what address had been given, to Homeland Security, to ICE?
I will again point you to page 18 of the transcript. Again, this was not rebutted. The prosecutor said, and again, I think it's unclear, but it probably was from his INS attorney, so he did look into it, which was there is no monitoring of this defendant and there are no court dates for this defendant. I'm sorry, for the victim. That was on the record. Whatever they're saying is not on the record. I mean, again, this is the whole point of preservation, and I think what Justice Higgins was talking about earlier, if I can go back to preservation, about the hearing aspect of it, is the fact that here we are in front of a court, and the people are severely prejudiced. Because if you're saying now, 3 or 4 years later after the trial, that we have to bring in sworn witnesses, we were sitting right there. We could have put the prosecutor up there for this hearing. We could have called Detective McHugh there. So now you come back years later and say, I mean, you say, well, we should have done this. A hearing means a full evidentiary hearing, which the statute doesn't say. In no case, as Justice Weber was talking about it, and I said, they said it hasn't been decided. There's no case that says a full evidentiary hearing. Now they're saying that's what it means.
Okay, you have a couple of things there. Why don't you, I'll ask you about the hearing now, and then we can go back to
Sure.
what you were asking before. But just to be clear on what the hearing, what the statute says itself, is it correct that it says an opportunity to be heard and, in addition to an opportunity to be heard, and conduct a hearing?
Conduct an inquiry and a hearing, which means both parties would have the opportunity to be heard. There would be a hearing in which both parties would get to address their...
The statute specifically says an opportunity for the parties to be heard and conduct a hearing.
Correct. And the court did that here. The court asked questions of officers of the court about what they specifically did to bring witnesses to a court. That both parties gave their recitations of the facts, and the court conducted a hearing.
Counsel, isn't that really an inquiry as opposed to a hearing, at least how we traditionally understand what a hearing's all about?
Not necessarily, because an opportunity to be heard, if we were actually getting to the actual words, an opportunity to be heard about whether the witness's testimony should come in, the court then conducts an inquiry, and both parties are heard about that inquiry. That happened here. And I would add, the prosecutor read evidence in this hearing. He read evidence from the second trial, the trial judge.
A hearing, I don't want to belabor the point, we've heard a lot, but a hearing usually involves a little bit more than an opportunity to be heard, which an opportunity to be heard, somebody's standing right in front of you, what do you know? What do you know? A hearing usually involves something a little bit more formal when that word is used.
Well, again, Your Honor, these things could have been addressed below if counsel would have...
You are right about that, but I just want, yes.
No, and I'm just saying that, like, what we're trying to say is we gave evidence, as I said, from the second trial judge. We gave what our interpretation of, or not interpretation, our efforts were. And whether a full-blown evidentiary hearing, I am not conceding by any stretch that that's what the statute says, because one, we have other cases where we've said, where prosecutors' representations have been found legitimate and not necessary for a hearing, because and that's with satellite TV, where the witness doesn't even come into the courtroom.
Counsel, to the extent that there was error here in admitting the statement, was it harmless?
Absolutely. Your Honor, I'll point you to the prosecutor. I mean, despite what they say, I'll point you right to the prosecutor's words. I am not asking you to rely on Darlene Leon's testimony. The incident was on videotape, right in front of the jury. Their main defense was justification. The jury literally saw with their own eyes the victim pass this defendant, go to the back of the car, smash the back of the car with the golf club, and then he's retreating, and then he's attacked.
I didn't get that.
I'm sorry, my watch. I apologize. The victim literally was going backwards. There was no justification claim based on this video. And nothing Darlene Leon, that's why I said we're not asking you to rely on him, because nothing he was going to say could have changed that. And they had his testimony.
Well, I know, Counsel, you're talking about justification. Your adversary spoke about justification, but I didn't see anything in the appeal that they questioned justification. I thought that it was the verdict was against the weight of the evidence in terms of the injury, whether it was
correct.
serious physical injury or not. I didn't see any mention of justification.
That's correct, but we also we didn't need Darlene Leon's testimony, as the prosecutor said, we're not relying on it for serious physical injury because we had graphic photographs that.
No, my point was I didn't see anything in the briefs that spoke about the failure to disprove justification.
That's correct. That's correct. Are there any other questions for me regarding this particular? If there are no other questions, I see my time has run out, and I would just ask that this court affirm the conviction. Thank you very much.
So, counsel, to that point, I'm sorry, to the point of your argument that the verdict was against the weight of the evidence, I didn't see anything there about justification, that perhaps there was an issue as to failure to disprove justification.
We did not challenge whether there was sufficient proof based on the evidence that came in that the prosecution had disproven beyond a reasonable doubt justification. That does not mean that the introduction of this complainant's testimony did not potentially contribute to the jury's determination here. So there are different inquiries. Whether or not we challenged the proof beyond a reasonable doubt of justification does not answer the question of whether the record as it stood, including the erroneously introduced complainant's testimony, did not factor into the jury's determination when it decided that the complainant, that Mr. Guzman was not justified. So I think that those are two different issues, and the fact that we didn't raise it does not conclude for this court whether or not this was harmless. I did want to just go back in terms of the prosecution saying that we didn't raise this hearing issue. Setting aside the hearing issue entirely and that preservation question, the defense clearly objected to whether or not the prosecution had actually exercised due diligence. So that's clearly before the court. The prosecution had full opportunity to explain the steps that it had taken to the trial judge. And so whether or not due diligence was exercised is a question for this court to determine, and it's fully preserved and before you. In terms of the second trial judge's statements that were read into the record, again, the prosecution was trying to get the trial judge in Mr. Guzman's trial to say, oh, because he was uncooperative, that's the basis for unavailability. That's not what the trial judge determined here. The trial judge said, I find that you've exercised the due diligence to find him. So the fact that they introduced that prior statement really, again, does not help prove whether or not they had taken the necessary steps.
But wasn't the trial judge and us by extension, aren't we allowed in viewing whether due diligence was exercised in a particular case to look at it through the lens of the defendant's prior level of cooperation?
You know, that may be a circumstance that can be considered, but I think it's important to recognize this is someone who had cooperated. Again, he had testified 3 different times for the prosecution.
You know, you say that, but I noticed in the record also that he took the fifth on numerous occasions. I mean, yes, there were certain questions in terms of his prior criminal background, whether he was selling drugs at the time, whether he ever sold drugs, things of that nature. But he wasn't really cooperating to that, to a large extent, based upon his taking the fifth on various questions posed to him.
I guess that is true. I mean, he repeatedly took the Fifth Amendment. But I would say, maybe I can just, if I may, just address the harmlessness one more time to kind of clarify our position. You know, the prosecution didn't introduce this testimony, but the defense read it extensively. So this was before the jury. And again, the complainant's words provided unique pieces of evidence that were otherwise uncontradicted in the record. Both parties drew on the testimony in their summation. The prosecution tried to distance itself from the complainant's testimony and didn't want the jury to think it had to solely rely on it because they knew he had been extensively impeached. But the prosecution still cited the complainant's testimony in the closing statement as it was trying to argue to the jury that these people had been acting in concert from the very outset, which again had a bearing on whether justification was disproven. And then finally, I would point out that if the prosecution, or if the trial judge had not erroneously introduced this evidence, it may have affected the defense strategy in this case. if the complainant's testimony wasn't in evidence, the defense could have at least argued to the jury, where's the complainant? Where's the star witness of this case? The prosecution or the defense would have introduced an uncontradicted statement from a defense witness that there was a gun among the complainant's associates at the time of this incident.
Why would the defense be precluded from arguing where's the witness based upon, just because the testimony is read into the record, they could still argue why is Mr. Leon not here in person?
Well, I believe that there was, when they introduced the evidence, they explained why he was not there to testify.
Because they couldn't find him.
That's right, but I'm just saying that
doesn't that serve the same purpose?
I mean, but the thing is that the testimony was present, and it was part of the evidence that was presented to the jury. If it hadn't been presented to the jury, then the defense would have been in a different position to make that argument. And the defense may not have stipulated to the authenticity of the videos if it knew that the complainant's testimony, the only person other than the defense witness who was actually present for the incident, wasn't part of.
Police officer could have testified to the authenticity. Does it fairly depict the area, the incident, et cetera?
He did not observe it personally, so.
But he could have depicted, he or she could have testified as to the authenticity.
If there are no further questions, I will please ask the court to vacate Mr. Guzman's convictions and remand for a new trial.
Thank you. Thank you both. Syndicate Media versus Comtext News. You may begin.
Good afternoon. Douglas Miller for Appellant Respondent. To please the court, the primary issue on this appeal is whether respondents will be held to the representations they made in their contract and the effect that has on the accrual jurisdiction for the application of CPLR 202, New York State's borrowing statute. Here, the plaintiffs are two corporations. First one, Syndicate. In its contract with the defendant, Comtext, it represented itself as a Delaware corporation with a principal office in Camden, Delaware. The other plaintiff, Al Bawaba, in its contract, initially represented itself as a Delaware corporation with initially a PO address in Amman, Jordan, and then in subsequent amendments under confusingly different name, represented itself again as a Delaware corporation, but with London address, and then finally in the final operative amendment, without a representation towards its status, but under the correct name, gave a different PO box address in a different city in Jordan. The question here is where, for the purposes of the borrowing statute, did their breach of contract claim accrue? The defense position is based on the representations in the contract, particularly that of the state incorporation. It should be Delaware, subject to a 3-year statute of limitations. The case law on this, as the court below noted, is not entirely clear. The rule for economic harm to a corporation for accrual is that it is either the place of incorporation or the principal place of business. In the New York State jurisprudence, there isn't really a bright line rule that I think anybody's been able to infer. When the Court of Appeals has addressed the issue, the last time I think they pointedly addressed it was in 1999 in Global Financial Corp, and they declined to make a rule finding that under the facts of that case, the claims were untimely under either under either suggested accrual jurisdiction. In 2010, the Court of Appeals, again, had not that specific issue, but in portfolio recovery, relied on the state of incorporation without further comment for a assignment from a Delaware corp to a non-Delaware corp.
Counsel, can I stop you for a minute? My recollection, the judge, with respect to the statute of limitations, it's not clear what precisely the ruling was, but that was in the record, correct?
The ruling on, her ruling, yes, is in the record.
It was on the record, and then the judge addresses, in the written decision, the merits of the motion, correct?
Yeah, so the way Justice Crane did it is at a oral argument, initially she said she was prepared to rule after hearing from both sides and did it from the bench, virtually.
The transcript wasn't so ordered?
It was.
It was so ordered?
Yes.
I don't know that I saw that in the record, a so-ordered transcript of the, can you tell me where it is in the record?
I do have that note somewhere, maybe on rebuttal.
Well, you can find it in rebuttal in any case.
Yeah, it was submitted for being so ordered. I recall it being so ordered. It's possible one of the notice of entries did not include that.
I'm sorry, counsel, you said it was submitted to the court? Is that
And
what
it
you
was so ordered. I'm fairly certain that the oral argument transcript on that portion of the motion was so ordered. The judge did rule from the bench, that I think is undisputed, on the statute of limitations issue. And
Right,
she
but to
notes
be
it.
an appealable issue, you know, obviously, because you just stated it, that it has to be a signed transcript, a so-ordered transcript. That's what or a written decision.
Yeah, and I understand that, and I believe there was a so-ordered transcript. I thought it was in the record. I have to go back and check. I did not myself double-check that this morning when I was getting ready for today.
Okay,
That issue hasn't been
perhaps
raised.
I didn't notice it, but assuming that it is not in the record, then I imagine you're going to quickly go get a so-ordered transcript.
I believe it was so ordered. It's possible one of the notices of entry, because there were 3 notices of entry, as you'll see in the record, because I think one had the decision, one had a transcript, one had nothing. They're all in the record, you know, obviously trying to be careful to include the full record. But I'm fairly certain it was so ordered. The judge ruled from the bench. She's ruled based on the Center Lane Partners case, this court's 2017 decision, which found that the plaintiff there, Oregon-based, was subject to the Oregon, even though it was a Delaware corporation, Oregon statute of limitations for 202 purposes because because that was its principal place of business. The issue of incorporation versus principal place of business was not raised in that in that case. I believe the court below, and I believe the respondent appellants presented it almost as precedential and essentially deciding the issue. But I note in 2020, this court in U.S. Education Loan Trust 4 again did the either-or formulation, either place of incorporation or principal place of business. I see my time is ending. Again, on the 202 issue, our suggestion is to rest on the representations in the contracts for the place of incorporation, which is Delaware, and that has a significant effect on the defendant's, or I should say the plaintiff's recovery.
Thank you.
Thank you.
Good afternoon, Your Honors. David Gordon of Mitchell, Silberberg, and Nutt.
So, counsel, is it your recollection or belief that that the transcript was so ordered as well?
Well, we don't have to go based on my recollection because it's in the record, and I'm looking at the record, and it is pages 22 through '84 of the record, and I see no notation that it was so ordered in any place. So
I'm sorry, sir, did you say you see no notation?
I don't see anything that says that it was so ordered. I'm looking at the document.
Okay, so
Pages
you have the
20
transcript that's in the record, but we don't see a reflection that it was so ordered by Judge Crane.
That's exactly right. Pages 22 through 84 of the transcript. I can see the last page, last 2 pages.
So 81 to 83, she did ask the parties to submit it. Is that correct?
81 to 83.
To remind her to so order it.
You know who shares?
In any event, there is no, your position is there is no so ordered ordered transcript.
That is right.
Okay, so move on to your next point.
However, to the extent that you are inclined to address the statute of limitations issue, which I don't think you should because, again, the appeal is not proper, there's Justice Crane's ruling was correct. It was consistent with 3 prior rulings of this court. There is the Center Lane ruling from 2017, in which the court held that the statute of limitations of Oregon governed because the plaintiffs had their principal places of business in Oregon, and they were incorporated in Delaware, and this court was crystal clear that it was the place of incorporation that governed for purposes of CPLR 202. That decision was consistent with the earlier decision in Brinkerhoff, where there was a plaintiff with a Georgia principal place of business and a Delaware state of incorporation. That decision was also consistent with the Sands Brothers decision, which this court affirmed in 2020, and in that case, we had partnerships with Connecticut principal places of business and Delaware state of formation. So there are 3 decisions by this court in which it has held that it is the principal place, where there is a difference between the principal place of business and the state of incorporation, and the plaintiff actually conducts business in that principal place. It is the principal place of business that governs for statute of limitations purposes. So to the extent that I would add that there's a slew of federal decisions that holds otherwise, that holds consistent with that, I'm sorry. To the extent that any other court has addressed this issue at all, there is not a single holding in which a plaintiff who maintains a real principal place of business that differs from its state of incorporations was held to be bound by the statute of limitations of the state of incorporation. So what they're asking you to do is make a ruling that is inconsistent with 3 rulings of this court, inconsistent with the federal jurisprudence on this issue, and unsupported by any other decision in this state. I would add, by the way, should you even need to get there, there is the question of equitable estoppel. Now, Justice Crane did not, before I get there, Abba Waba has not been incorporated in Delaware since 2006 in any event. And the defendant knew that because, as I think there was an allusion to it, there were multiple amendments to the agreements between the parties. Yes, it is correct that the original document and then the 2 initial amendments said incorporated in Delaware. However, in 2006, those references were eliminated, so therefore the 3rd and the 4th amendments eliminated the references to incorporation in Delaware. In reality, Abba Waba is not incorporated in Delaware, it's incorporated in Cyprus. And by the way, you'd think with their burden of proof, if they could prove that Delaware was the state where Abba Waba was incorporated, they'd be able to just simply get the court record, the public record. Well, and I'm sorry, may I just one last point on equitable estoppel? We don't think you'll need to get there at all because the precedent is so strong in our favor, but I would note that Justice Crane sidestepped that issue when she said, if I rule that New York statute of limitations governs, then I do not need to get into equitable estoppel. At that point, I said, that's correct. However, if there were some reason why you would wish to go with Delaware, and I don't think that would be appropriate, that would just take us right into the equitable estoppel argument, which Justice Crane left open, and there was substantial grounds for that argument. Thank you.
Thank you.
I'll accept, I guess, my opponent's representation on the record. I did not bring a copy with me, so I cannot double check, but my recollection is there was a so ordered transcript. We will deal with that accordingly. To respond to a couple points.
Well, you understand that if there is no so ordered transcript, it's not appealable here, and we won't, okay.
The other issue for them is, of course, the time to appeal hasn't started to run then because I don't have an appealable order, but that's a different issue to be dealt with below. To just respond briefly to a couple points that my opponent made, there are 3 cases, recent cases from this court that relied on the principal place of business, Verizon Directories, Gordon versus Crendo, and most recently, 2019, Interventure 77 Hudson. He doesn't, at least in oral argument, did not distinguish those. If you look, they're not too distinct from this one, where you have 2 corporations with no domestic presence, according to them, beyond which on the burden, we rely on authenticated contracts and the representations therein. For syndicate, I think it's an easy issue, whether it's a place of incorporation or place of business. In both instances, they say Delaware in their 2014 contract, which they then sued on in 2019. I don't think there's an evidentiary issue there. For Alba Waba, it's a more complicated issue, but just because they didn't repeat a representation in the contract in a subsequent amendment doesn't necessarily affect anything one way or the other, because they didn't withdraw the representation, they just omitted it. They omitted a bunch of things from some of those amendments. Some of them mentioned nothing about royalties, which is what this case is about. Does that mean we don't owe them royalties? Under their theory, I think that would mean that. I don't think that's right. On the estoppel issue, there's a procedural point in our papers on it. They argued that before Justice Crane in 2019 on a discovery motion, trying to get unlimited discovery. They lost. They got a so-ordered transcript that time too. They filed a notice of appeal. They never perfected. It's an unperfected appeal. I think that procedurally doesn't put it properly before the court. Substantively, for estoppel, they need to show an affirmative subsequent action by the defendant that lulled them into, via reliance, into not bringing a timely claim. I don't think they have the facts on this record. Are there further questions?
Nope, thank you.
Thank you.
Brown Media, I'm sorry, Brown versus New York Design.
Good afternoon, Your Honors. Nicole Bulkley for the appellate respondent. The appellant argues here that there are two issues with the lower court's decision regarding whether New York Design had actual or constructive notice of the cracked tile where the recording device was found. The lower court relied on a misrepresentation of testimony cited by the plaintiff.
So I'm just going to, I'm going to go to constructive notice because the company said that they had people who regularly inspected and walked in to clean and inspect. This was a hole the size of a grapefruit. So you're not questioning or challenging the issue of constructive notice, are you?
Yes, Your Honor, we are challenging the issue of constructive notice on the basis that the complaints that were made by the plaintiffs, there was, I believe, a few plaintiffs that made some general complaints about.
There was a gaping hole the size of a grapefruit that was dirty with debris and everything else in it, that the place was not clean, that this was the state, this was the condition. I think it went on for months. Was it ever addressed?
The NYCD conducted general, maintenance of the women's bathroom, and a general inspection, obviously did not reveal.
General or specific would reveal a grapefruit size hole in a wall.
We believe that the issue here is that there was no, as far as constructive notice goes, there was not it was more of a general inspection. So, when they went to go obviously examine this, there was not a sufficient amount of time that this hole had been present. None of the plaintiffs testified how long this hole had been there.
At least one person, and then we get to actual notice, said she actually told, it was a porter or an employee in the building of this hole in the wall 6 months earlier.
I believe that's where the misrepresentation comes in, Your Honor. She did not actually say she saw the specific hole. She testified that there were holes in the tiles in the bathroom. She said that she saw that specific hole prior to the incident, but
how much prior is necessary for there to be the kind of notice that would require a grapefruit-sized hole in a stall to be repaired?
The First Department does not specifically at this point that I found address how long the specific time frame is, but in this case,
Well, how much do you think? I mean, how much time? I mean, you're saying it's not 6 months. Well, it was certainly for a period of months that this existed. It wasn't just chipped away recently.
One or more of the plaintiffs actually testified that they had only seen the hole for a week prior to, and not the specific hole. They had only noticed that there were cracked tiles.
But you still have Ms. Krill's testimony, who says that she saw the hole in toilet and in the wall behind. It was 2 to 6 months. Isn't that enough to raise an issue as to whether or not the defendant had constructive notice of a condition in the bathroom which permitted the installment of a camera.
Yes, Your Honor. While she says that she saw that whole 2 to 6 months before, her actual complaints to Justin Cohen, the cleaning crew, were not about that specific hole. Her testimony, 3 pages, I believe it's on page, her testimony starts on page 1271 of the record and goes on this issue through 1276 of the record. The beginning of the questioning on this point, she starts to talk about—
Thank you. You've given us the pages, and I've given you more than enough time,
Okay.
considering you don't have any opposition. Thank you very much.
Thank you.
People versus Yolentin Concepcion. I'm sorry, People versus Lamar Davenport.
Good afternoon. Karen Brill with the Office of the Appellate Defender for Lamar Davenport. When the trial court ruled that Mr. Davenport's undisputed psychosis could not legally qualify for the mental disease or defect defense, because that psychosis was brought on by PCP, the court created a restriction on Penal Law 4015 that was nowhere to be found in the statute's text, and that was contrary to both the science of psychiatry and the common understanding shared by over 4 decades of New York courts that all psychotic states, including substance-induced ones, present issues of fact for the fact finder, not threshold issues. Yes.
This is an unusual case in that we rarely get to see that 2 psychiatrists are on the same page and find that a defendant suffers from psychosis. Usually, there's a battle of the experts, and it goes to the jury. But it has consistently been that it seems in every case, whether or not it's a psychosis that's voluntarily brought on by the ingesting of drugs, and then temporarily, the person is under a temporary psychosis, or whether it's voluntarily brought on by the ingestion of drugs, and then it's a permanent sort of psychosis. In all instances, it seems that these cases have gone to the jury.
Yes, exactly.
Right? In the instance where, in this instance, where it was temporary, it was voluntarily done, and it was a temporary psychosis, is it appropriate under the penal law for this to go to the jury?
Yes, Your Honor, because what Penal Law 4015 tells us to look at is someone's mental state at the time of the offense. And at the time of the offense, he was undisputably psychotic. What the trial court did was read a policy determination into Penal Law 4015, rejecting certain psychoses based on their origin or their duration that the legislature never made. And the way we know that is because it's not in the plain text of Penal Law 4015. I've provided several examples of other states that explicitly excluded these kinds of psychoses from the scopes of either their insanity statutes or their voluntary intoxication statutes. New York does neither. And that has to be read as a matter of legislative design.
Just conceptually, is the voluntary consumption of a substance, is that a mental disease or defect? I mean, isn't that what occurred here?
It is because he became psychotic. And our courts have always understood that when someone is psychotic, they have a mental disease or defect. There are actually several cases—
Even if they imbibe voluntarily?
Yes, Your Honor. I'd actually point to the Court of Appeals in People v. Santorelli, which reviewed a case where Mr. Santorelli had a temporary psychotic state from amphetamine use. And the Court of Appeals actually recognized that that temporary and voluntarily—
But isn't there a distinction there? Isn't there, in that case, the use of drugs altered the brain in some fashion, so that person does have a mental defect, right?
That's exactly what happened here. Because of his PCP-induced psychosis, Mr. Davenport sincerely believed that there were demons in Ms. Hines that he had to expel, and both psychiatrists credited that.
Counsel, in Santorelli, the court didn't really address the definition of mental disease and defect with regards to the penal law. It was in the context of a Molyneux application.
Yes, Your Honor, absolutely. But when we're looking
Isn't that different?
It's different insofar as it was implicit in Santorelli, and I'm asking you to make an explicit finding here. But if you read Santorelli, the case makes no sense without the understanding that that charge was validly before the fact finder in the first place. And that's the same understanding that several appellate division court cases have also operated under, that there was an issue of fact for the fact finder in the case of a temporary and substance-induced psychosis. And again, the way we know that is because New York statute does not resemble the other states that have explicitly precluded this defense from its plain text. And that's why, in all of those cases, when we're looking, we have an undefined statutory term here, and given that we're looking for its plain meaning, the plain meaning that has been shown by all—
So the DSM-5, what happened here? They classify what happened here to be a mental disorder.
Yes.
Correct?
Yes.
And the DSM-5 also goes on to say that in defining the mental disorder, they're not attempting to define any legal standards, correct?
Yes.
Would you agree that the definition of mental disorder as pertaining to the DSM-5 differs or arguably differs materially from what is intended for mental disease and defect in penal law 4015, whatever it is?
Absolutely, Your Honor. What I'm saying is that courts have understood mental disease or defect to encompass diagnosed psychotic conditions. The DSM-5 is helpful for helping us find out where there is a psychotic
But
condition.
we're not when we're talking about the voluntary ingestion of drugs. I mean, that's what I don't understand your argument, because that would mean, I don't know that the legislative intent would be that anytime someone voluntarily took drugs and therefore there was some type of psychosis that resulted, that would mean that they would not face the consequences of their actions.
Your Honor, I don't think that's a fair characterization of what the results of being found criminally not responsible would be. Mr. Davenport would face the same potential of indefinite confinement that anyone who is found not responsible.
Well, except that here it's this agreement that this is temporary, and in fact there was further agreement that, but not for his ingestion of PCP, he would not have suffered this psychotic, whatever you want to call it.
Right, and so when we talk about mental disease or defect, you're normally talking about schizophrenia or paranoid schizophrenic, et cetera, which seems to suggest some type of lasting condition and not a temporary condition, temporary psychosis, again, as a result of voluntarily ingesting a drug.
I understand, but the requirement for a permanent condition is not in the statute. The statute points us to someone's condition at the time of the crime, and he was psychotic at the time of the crime. And just to go back briefly in terms of what his potential confinement would be, even though it was temporary, Mr. Davenport was also diagnosed with several substance use disorders, and this court has found that someone can be confined under the confinement framework where there's a risk of dangerousness caused by their inability.
Well, that's another issue, because given the fact that it was a temporary psychosis brought on by his use of PCP, would he really at that point in time, would you really argue that he should be confined to a psychiatric facility?
I mean, I can't speculate as to what would have been argued, but it definitely has happened. There are cases that I cited in my brief where someone was detained due to a substance use disorder because of the risk of their dangerousness upon using substances. And that's the same risk Mr. Davenport would have faced here. If I can just add—
I just have one other question.
Yes, Your Honor.
Just to a little bit further with regard to the statute, it talks about engaging, when the defendant engaged in the prescribed conduct. And this was asked by my colleague, Justice Rodriguez. It says he lacked criminal responsibility by reason of mental disease or defect.
Yes.
Mental disease or defect is not defined in the statute, and mental disease and defect is not defined in the DSM. But the DSM, when it speaks of, I think, a mental disorder, it talks about something permanent. And I mean, the DSM-5 is where we would go for psychiatric illnesses. It talks about something permanent. It is not talking about something temporary. It talks about schizophrenia, something organic, or perhaps something permanent that is brought on by the voluntary use. So, for example, where somebody takes PCP or whatever drug long enough so that it changes the chemistry of their brain and they are then schizophrenic.
So that's
would that be, does that seem like a fair difference to you, that these, neither one of these things is defined, and where it is defined in the DSM as a disorder, disorders don't consider this sort of temporary state?
So that's how the DSM-5 defines an organic disorder. It does consider PCP-induced psychosis to be a mental disorder, and it puts it in the same section on all psychotic disorders alongside schizophrenia, alongside delusional disorder. It's listed in
Right,
that
but does
same
it matter if it's permanent or if it's temporary?
No, Your Honor, because the legislature has given us no guidance to suggest that it does, and that's the way that the Court of Appeals in Santorelli and several appellate divisions have understood the statute. Because of that, we ask you to reverse, and I'd also like to address my excessive sentence argument on rebuttal. Thank you.
May it please the Court, Alexander Michael on behalf of the people. Defendant is asking to be treated as though he has a mental condition like schizophrenia or intellectual disability.
So what do you say to your adversary's argument about the plain reading of 40.15?
Well, the language and structure of 4015 require two distinct things. One, a lack of substantial capacity, and two, by reason of mental disease or defect. My adversary's reading of it actually sort of conflates those two things and allows the lack of substantial capacity, in this case the delusions, also to account for the mental disease or defect. But when you look at those two things distinctly from one another, you see that the mental disease or defect is not the underlying source of the lack of substantial capacity in this case. The underlying source of that lack of substantial capacity is, in fact, defendant's voluntary ingestion of PCP. And that's the kind of analysis that the Appellate Division 3rd and 4th Departments have both embraced in their decisions in Gillis and in Fitz-Randolph. And that's the exact same kind of analysis that the Massachusetts Supreme Judicial Court embraced in multiple decisions discussing this precise issue. Those are cited in our briefs there, DePadova and Dunphy.
These cases have always been sent to the jury.
Well, that's an interesting point that you raised, Your Honor, because in Gillis and Fitz-Randolph, there was a dispute, as you were pointing out, I believe, to my adversary. There was a dispute as to what the source of the lack of substantial capacity was. There was contradictory evidence as to whether it was due to voluntary ingestion of drugs or whether it was due to an underlying mental disease or defect. And when there's that sort of dispute, of course, the issue absolutely should go to the jury. And what's interesting here is that if you accept the defense position, it's not clear that the issue should have gone to the jury in this case, because there was no dispute between the parties as to whether there's a lack of substantial capacity, and there was no dispute as to its source. Its source was PCP, or its source was, PCP ingestion. So if there's no dispute on that issue, it's not clear what you would submit to the fact finder in this case. The defense's position, I think, would entail a motion for a trial order of dismissal, a granting of a motion for a trial order of dismissal under these circumstances, because there's no dispute as to where what the lack of substantial capacity derives from. The only issue here is a statutory one. So for that reason, submitting it to the fact finder wouldn't accomplish anything in this case. Now, as to defendant's mental disease or defect in the issue of whether he has that, it's clear that he has a normal brain with a normal mental status, and he chose to temporarily disturb that mental status by ingesting PCP, even though he knew that he had a history of violent and delusional behavior on that drug.
Would the argument change if he had been ingesting PCP for, I don't know, a decade, 2 decades, and that changed the chemistry of his brain? Would the argument be different then?
Yes, absolutely. The argument would be different. And this is something that was explored at length below. That would be a fixed frenzy, I think is the phrase that was used at common law. And that would be something that would be recognized as an underlying mental disease or defect, not brought on by the immediately prior ingestion of PCP, something that's an ongoing underlying mental condition.
I thought the doctor used the term settled insanity.
Yes, settled insanity.
I don't know if that's any more or less appropriate than what you just said. Are they both used interchangeably?
That's my understanding, yes, Your Honor. So settled insanity would account for the same phrasing. Now, in anticipation of my adversary's argument on the ES issue, I would like to point out that on the subject of his sentence, defendant is essentially arguing that he deserves a light manslaughter sentence because he's not guilty of murder. But of course, the sentence he got already reflects the fact that he's not guilty of murder, and various considerations demonstrate that he deserved a substantial manslaughter sentence in this case. First of all, this was a brutal and intentional homicide, which of course would normally entail a guilty verdict as to murder, but of course he got an extreme emotional disturbance finding from the bench trial, from the court. And then second of all, defendant had a history of violence, including violence directed at his girlfriend, the victim in this case. Finally, he has repeatedly tried to shift blame for his conduct, first by suggesting that somebody had drugged him involuntarily, and later by blaming his drug problems partly on the victim herself. Unless the court has any questions, we ask that the court affirm.
I want to point out that none of the cases that respondent cites in his brief from other states have a mental disease or defect offense that matches New York's. And that's exactly the point. New York has a specific statute that is unlike other states that have given indications either in its legislative history or in its plain text that these kinds of psychoses are specifically meant to be excluded. Without that kind of guidance, there is just no way to decide. The legislator wanted to exclude some psychoses, but not others. The two cases that our respondent cites are not apt. Fitzrandolph, there was absolutely no testimony that Mr. Fitzrandolph was psychotic from his drug use. There was a question of whether he had a different mental illness or whether he was intoxicated. But there was no testimony that the intoxication led to psychosis from that drug use.
Counsel, why don't you address why we should reduce the defendant's sentence?
Sure, Your Honor. At base, it was undisputed that at the time of this homicide, Mr. Davenport did not have a sane intent to commit a homicide. And in the aftermath of that homicide, his behavior was so exceptional that 50 different Rikers Correction officers signed a petition attesting that he was a model detainee, a role model to those around him, a voice of reason. And he took his rehabilitation so seriously that his supervisor in treatment specifically credited him for his dedication and progress. What happened, this homicide was horrific. But Mr. Davenport is not someone who had a sane intent to cause harm. He had no prior criminal convictions, and in the aftermath, he dedicated himself to total remorse.
What about the prior instances of violence that he had with the victim here, and well, address that?
I think it goes beyond the record to say there were prior instances of violence. There were prior instances of aggression, and I think that's right. They occurred within that same substance use disorder that he sought treatment for after this crime. There is testimony that he was intoxicated at each of those instances. He was sober from when he entered Rikers, and the corrections officers clearly credited his rehabilitation because 50 of them singled him out as someone who was worth being considered a model in the facility. So because of that, we think a lower sentence is appropriate.
I'm going to ask you to go back. You were in the middle of distinguishing the cases. If you'd finish that, please.
Yes, sure. In Gillis, there was a factual question of whether Mr. Gillis was actually psychotic from his drug use or whether he had actually feigned his symptoms. And so there is language in Gillis about the distinction between a functional psychosis and a real psychosis. By real, they clearly mean not fabricated. And I would encourage this court to look at the district court opinion in Gillis when it was upon habeas review for further factual context for the third department's language there. But what the third department found was that the totality of the evidence, including shifting testimony from the psychiatrist and Mr. Gillis's own shifting testimony, created factual problems with those witnesses that meant that the mental disease or defect defense was not sufficiently met such to overturn the conviction on appeal. But that was a recognition that these were issues of fact for the fact finder. And that's all we're asking for here, was that this should have gone to a fact finder.
In light of your friend's point during his argument, if there was agreement between the experts here, what was the issue of fact? And relatedly, what was the remedy that you would like in light of the fact there was that agreement?
We're seeking a new trial. A fact finder could have either credited both experts, credited some of one expert, some of the other, or credited neither in terms of the connection between Mr. Davenport's psychosis and his decision to commit the homicide. That's a fact-specific finding. That was the role of a fact finder here, and that's what the fact finder did not get to do.
Wouldn't that be a legal determination as to whether temporary psychosis constituted a mental disease or defect?
Yes, exactly. What I'm saying is the question for the fact finder was whether or not he either did not know the nature or consequences of his actions or that they were wrong as a result of that psychosis.
So was that not determined by the fact finder? I mean, this is a bench trial. So was that not determined at trial?
No, Your Honor, because the fact finder would not allow, Yet the fact finder would not allow herself to consider that defense because in operating as the trial court, she precluded it at the threshold. And that's the word she used, threshold. So she actually told herself, when I'm acting as the fact finder, I can't look at this as the mental disease or defect defense, just because of the nature of his psychosis, not because of the connection between the psychosis and his actions. So on retrial, it should be charged to the fact finder, whether that be the jury or a bench trial again, to actually determine whether or not the defense was met. And that's what Mr. Davenport was deprived of here. So
Whether the defendant was what? I'm sorry.
whether the mental disease or defect defense was met.
Whether the mental disease or defect.
I apologize for the lack of enunciation.
Thank you.
Thank you.
Thank you both. Epic versus Malta.
May it please the court. My name is Tom Lambert for the appellant. This is a motion for summary judgment for rent based on documentary proof of an alleged rent history.
Mr. Lambert, can you address the judgment that was entered against your clients? And if I'm not mistaken, the guarantors reaffirmed the guarantees. It was I think, close to $900,000 judgment. Based on the entry of the judgment, how do you have a leg to stand on?
Well, that judgment was for rent for about $800,000. And that $800,000 was paid. In other words, if you look at the alleged rent history here at 222 of the record.
But didn't the trial court make different factual findings with respect to whether or not the underlying judgment was satisfied as opposed to paying your ongoing obligations for rent?
No, the judge in this case, in his opinion, he finds that that first $800,000 was fully paid, that they paid over $3 million after that judgment, which covered the $800,000 and more. But he also finds that, based on the rent history, that there was defaults in paying continuing rent into the future pursuant to the requirements of the stipulation. So he does find, but that stipulation, they were evicted because they didn't comply with that stipulation. There was a finding that they didn't comply with that stipulation. But that doesn't mean that all the rent that they're seeking in this case was in any way proved by that case. Not at all. In fact, Judge, if you take a look, there's some point that the judge also makes that the stipulation of settlement included a rent account statement. If you look at the rent account statement that was what was included in the stipulation of settlement, it's at page 260 of the record. I can't see. It's entirely different. It doesn't. There's no stipulation to any amount. When you read that rent account statement, the 260, that was stipulation of settlement was so-called based upon, the amount of the settlement is nowhere contained in that rent account statement. The amount of the settlement is written by hand underneath that statement. $18,000 is added for attorney's fees, and that's how they got to the agreed-upon settlement amount. The tenant just wanted the case settled, was ready to pay. Okay, that's the amount, we'll pay it. And then the stipulation was made that they had to pay that amount plus continuing rent. And that's where the issue is. But Judge, this case, this motion for summary judgment is based on documentary proof of an alleged rent history, which starts at page 222 of the record. And there's no testimony anywhere that this rent history was prepared in accordance as required by People versus Kennedy and 4518. There's no evidence, no proof anywhere that this rent history that this case is based on was made pursuant to established procedures for the routine, habitual, systematic making of such a record. In other words, the guy glibly says the rent history was made.
Mr. Lambert, didn't the managing agent say that the rent history was prepared in the ordinary course of business.
Yeah, glibly, he said it was made in accordance
Well,
with.
but why isn't that sufficient?
Because there's a second branch, he's got to say that it's made in the, as we say, we call him up on the stand on a landlord-tenant case, and the landlord gets up and says it was made in the regular course of business, and it was in the regular course of business to make it. I'm not quite sure whether they really understand what they're saying when they say that. But the point is, Judge, that there's no proof here that there was a routine, and the judge creates a kind of commercial landlord exception to the hearsay rule.
Thank you, sir.
What he says, he finds that it is in the regular course of a commercial landlord's business to maintain. But that's not the question, whether a commercial landlord should have a routine, or most do, or normal ones do. The question
Thank you. Thank you very much.
Sorry, I didn't hear it.
It's quite all right.
Okay.
Mayora Estates versus Century 21.
Don't make me do it.
May it please the court, James McGuire for the appellants. When Century 21 negotiated in 2010 to get 3 more floors, that's what it did. It negotiated. And when you negotiate, you pay a price. And the price it paid is it agreed that it would, that to the simultaneity and the automatic termination provisions that we've set forth in our brief. That means it agreed that if it wanted to renew one of the leases, it had to renew both. That's the simultaneity requirement. Had to do them both at the same time.
Can I ask you a question?
Sure.
Why didn't, when this negotiation was done, as you're suggesting, why did not it include the springing lease to say that springing lease also terminated? It seems to me we wouldn't be here then.
Well, there's a number of answers to that one, which is, first of all, that the later in time 4-5-10 lease controls over the conditional lease that was executed much, much earlier. But the other answer was going to be my second independent argument for affirmance, for reversal, Your Honor. But the second one is that there's absolutely no need to make reference to it because it was clear that it had become a dead letter by that time, and it was not in effect. And so why would it? But even if it were relevant, you've got a fundamental principle of law that a subsequent agreement between the parties covering the same subject matter, the later agreement controls over the earlier one in point of time.
Except here you have essentially, which I've never seen, quite frankly, a contingent lease, I guess is the best way to call it, which would come into effect if the retail lease gets terminated. So doesn't the springing lease or contingency lease, doesn't that have to also be given legal effect?
Well, okay, so again, I'm happy to follow the questions, and they go to the second reason why your court needs to reverse. That my adversary consistently says, in oral argument, and consistently says, hey, the provision is 2.1 of the conditional lease, not the first one that states the condition of precedence, it's 2.1. And that provision, for the conditional lease under his erroneous reading that it governs, the existing lease, the retail lease, and the sublease have to expire by their terms. The existing lease did not expire by its terms. Somehow Justice Borak was persuaded otherwise. It expired precisely because they did not comply with 89F of the 456 lease. And as a result of 89J, it terminated. It didn't expire pursuant to its terms. Now the sublease did not, has to also expire pursuant to its terms under 2.1. That's a plain language. It must expire pursuant to its terms.
I'm sorry, counsel, I'm sorry to interrupt you, but I'm going back to section 1 of the springing lease, which says, which discusses termination for any reason. So wouldn't termination of the retail lease because the 456 lease wasn't renewed, wouldn't that then?
Absolutely not.
Why?
Absolutely not. Plain language, Judge.
Why? Tell me.
Okay. Provided there's a number of conditions precedent. But the whole clause begins with provided that. Classic condition precedent language. And then there are all kinds of considerations and factors that have to be met. And then at the end, if they're met, then the landlord has to demise the precedent, the premises. So they're clearly conditions precedent. And one of them is stated outside of parenthetical, and the one is stated as inside the parenthetical. And then now you're focusing on the condition precedent that's stated inside the parenthetical. And it says that provided if the existing lease shall have been terminated for any reason. But that's not enough. You have to keep reading, Judge. Sure. And it says, provided that they shall have been permitted to return to landlord and remain in possession of the demised premises as a direct tenant of landlord pursuant to the terms of the existing sublease. But they became the direct tenant years and years and years earlier. They were already the direct, not years earlier. They became the direct tenant years later when an assignment became effective. And once the assignment became effective, there was no longer any sublease. So it's just terminating for any reason is not enough. They think that it's not enough under 2.1, but they're dead wrong on their claims that expired, that the retail lease expired to its own terms. But let's get back, Judge. What they have to say is something that's preposterous. The parties expressly agree in the much later 456 lease. They expressly agree that if the tenant says, I hereby acknowledge and agree that if the simultaneity requirements is not met, then it automatically terminates. What they want this court to rule is that that language actually says, quote, tenant hereby refuses to acknowledge and hereby refuses to agree. Courts don't read provisions of contracts to mean the opposite of what they say. They read contracts to mean what they plainly say. They don't like the deal that they made, but that doesn't excuse them. That doesn't give them a hook to get out of their deal. It's even worse. It's even worse. Because all they did was send in a retail lease, they cherry-picked, and they sent in the notice for the retail lease. Therefore, they violated the simultaneity requirement. Under their view, they didn't even have to do that. They could have done nothing. Waited until the last day where any notices still sent nothing. Under their rationale, okay, well, that would have affected a termination of the lease, and therefore, okay, what happens? As a result of our non-compliance with a contractual requirement, we don't pay a price. We get rewarded. We get a windfall. Who pays the price? The landlord pays the price in the form of an extension for 75 years. That just makes no sense. And no court, I submit that it's impossible to accept that. And then finally, the cherry picking point. That's what this obvious purposes of 89F and J are. 89F and F say, you got to pick both. You can't just pick the one that you think is more favorable. And how do we know which one is more favorable? The retail lease? Because that's the one that automatically terminates if you don't execute it in 1969. And their own CFO says that it was in 1969, the rents were fixed at something like, paraphrase it, dramatically under market terms. So of course they want that one, but they don't have the right to pick just that one. They have to pick them both. They made their bed, and they don't want to lie in it, and they want the court to misinterpret the words. There are more reasons why the conditional lease does not, by its terms, apply. If you just give me 1 minute, and then more come up on reply, fine. But they deny that what's stated in Section 1 are conditions precedent. They don't even mention it. You can't read them without understanding that they're conditions precedent. It's not possible, provided that if or various things occur, then they have to demise. My clients have to demise the premises. My adversary has no answer to this question. You may want to ask it, Justice Singh. Suppose that at the time that you claim that the springing lease commenced, there was a default in payment of rent and the cure period had elapsed. Would you claim that it could nonetheless, you get the benefit for 75 more years? If they say yes, that's absurd on its face, and you should turn a blind eye to anything else they say. If they say no, it can only be because in Section 1, it specifies those circumstances that must take place, and one of them is that there can't be a default that continues beyond the cure period. And so that's a condition precedent. And if that one in Section 1 is a condition precedent, the other ones are too. They've never claimed that there was internment. This case is over. Thank you, Your Honors.
Good afternoon. May it please the Court. Evan Krinnick here on behalf of the respondent, Century 21. The springing lease provides valuable rights to my client that they negotiated for in 1997 with the landlord's predecessor. The entire argument presented here about Section 1 of the springing lease is not preserved for review. But be that as it may, Section 2 of the springing lease clearly, as Judge Borick found, clearly gives my client the right to a new lease, not the retail lease, but a new lease whenever that retail lease expires, either in 2062 or earlier at the end of one of its earlier terms. There's nothing ambiguous or unclear about that. Section 1 of that lease does not eviscerate Section 2.
So it's your position that the springing lease would apply to any circumstance if the retail lease was terminated for, say, non-payment, for any reason?
If it expires. The word is expired. If it expires under Section 2, either in 2062 or at an earlier time, then the right we bargained for is that a new lease is formed the day after the lease expires. Now, because this was a new argument, and it's not in the record, and the procedural context of this case is bizarre. They filed an amended complaint. We moved to dismiss one aspect of that complaint where they claimed that they put us on their default notices properly. That's all we moved for. We didn't answer. We didn't counterclaim. We didn't seek discovery. They cross-moved for summary judgment on the whole case. We don't have a chance to litigate. They make an argument at the lower court limited to the fact that the springing lease is negated, nullified, modified by the 456 lease. That's wrong. There's nothing in the 456 lease that modifies the springing lease. It's a right that exists, and the affidavit in the record makes clear the person who negotiated those leases, those two leases survived together. Now we get on appeal, and they make a whole new argument, and they argue that Section 1 creates conditions, and those conditions weren't met. But if they had argued that below, and it's unpreserved, and they acknowledge it's unpreserved in their reply brief, but they say there's an exception.
Let's assume, for argument's sake, that's a legal argument and can be raised. What's your response to it?
Well, the response is the context of the 1997 lease is critical, because the 1997 lease was signed the same day that we sold the building to the landlord's predecessor. The 1997 lease was signed a month after we signed the third floor lease, and the third floor lease expressly requires the landlord and tenant to enter into a lease to allow the retail lease to extend to 2096, the same year the third floor lease, a 99-year lease created in 1997, was created. None of that's in the record because this argument wasn't raised below. So the context of the 1997 lease, it wasn't some surprise, it wasn't some hidden agreement. It was significantly, a lot of consideration went into, we're selling the building, we're getting the right to retail lease forever. And that's the context in which you have to read the 1997 lease when it springs into effect with a new lease as soon as the retail lease expires. Now, granted, in the 456 lease, if we didn't want the 456 lease, we're still getting the retail lease. But if we don't want the retail lease, then we don't want the 456 lease. And that's all that 89 says. If you're going to renew them, you renew them together. But nothing in there gives up our right to the retail lease to 2096 at all. We bargained for that right. So there is no conditions in Article 1. Article 1 and Article 2 of the springing lease have to be read together. Their interpretation reads Article 2 completely out of it. It simply says, you get a springing lease in 2062 if you're still around, or you can get it if you're a subtenant and the landlord consents to your attornment. That's it. Well, that gives us ice in the winter. We knew we were going to be a direct tenant. The lease had already been assigned to us. It's mentioned in the whereas clause in the springing lease. It was a question of when it was going to be effective. So that interpretation leaves us with no rights.
Well, sir,
With a springing lease, that means nothing.
Did your lease terminate or did it expire?
It expired at the end of its term when we did not renew both leases together. And terminate, when we didn't renew both leases, Article 89 says your leases terminate expire at the end of its term. We didn't renew it. It expired. Springing lease comes into play. That's exactly what it was there for, to protect us. Look, the practical is, you know this space. The retail lease is what we want. That's where our store is. That's the critical economic advantage to us. We sold the building. We have 3, 4, 5, and 6. But the retail lease is where we want our space. We bargained for that right in 1997, and nothing this landlord did since then eviscerated that right. So preservation is here important because I don't think it is a question of law. I think if there's any question about what Article 2 or the springing lease means, we have to have a time to put it into context. But I think on its face, as Judge Borak ruled, Article 2 makes it perfectly clear. And to answer Council's question, absolutely, if we're in default, we don't get the springing lease, because you have to read Article 1 and Article 2 together. You can't cherry pick one, cherry pick the other. What they want to do is take the parenthetical in 2 and say it only applies to the parenthetical in 1. Why? Is there some rule of construction that parentheticals only apply to each other? They're in 2 separate clauses. They have separate and independent meanings. Simply because they're both parentheticals doesn't mean the parenthetical in 2 only modifies the parenthetical in 1. There's no logic to that. Paragraph 2 gives us the rights to a new lease anytime the retail lease expires pursuant to its terms. Be happy to address any questions.
Thank you.
Thank you.
Excuse me, Your Honors, that is perhaps the most disingenuous argument I've ever heard. First of all, it's clearly preserved. It's a pure question of law. There are hundreds of cases that say you can raise on appeal for the first time a pure question of law. We're talking about a pure question of law in how you interpret language in a lease. Second, all these complaints about a motion for summary judgment, we made a cross motion for summary judgment when they moved to dismiss. They objected. They abandoned it. They said nothing about an oral argument. We pointed out in the appeal that they had abandoned it. We cited a First Department case that says in this same context, you can make a cross motion to dismiss. They never objected to that. Now they're trying to make it sound like they did because they want to try to inject supposed factual issues here. Factual issues that are not here. It's all about how you interpret the lease. Look, they can say, oh, they've just conceded that Condition 1 sets forth conditions of proceeding because he says that they can't get the lease under Section 1, which they claim doesn't govern the circumstances of getting the conditional lease at all. You gotta be blind. If you read the words, that's not what it says. Provided that, if blah, blah, and blah. So they've conceded, so the other ones are too. They don't claim there was in a tournament. That's over. That's completely, the whole case is over. Not only do they acknowledge that, look, let's just understand something. At the time that the conditional lease is entered into, they have some peril because they're the subtenant. They lose their valuable subtenant, the one they keep saying is so valuable to them, right? They lose it because, potentially lose it because of actions by Woolworth, their tenant, who's the tenant under the main lease, and their lease, right? So they need some protection, and Section 1 gives them some protection. If it terminates for any lease, if Woolworth causes that lease to terminate, then what happens? They get an opportunity to stay on there buying a tournament. That didn't happen. There's no way it could happen when years later they become the assignee. They're in the same position as with Woolworth. Woolworth can't do them any harm anymore. And then they negotiate this the 456 lease, and they expressly agree. Tenant hereby acknowledges and agrees that if it doesn't meet the simultaneity requirement, its retail lease is over. There's no fingers crossed exception to contract interpretation, but they want your honors to buy one. And the law just doesn't allow it. Thank you, your honors.
Thank you. Thank you both. People versus Anonymous.
May it please the court, John Vang for Appellant Anonymous. The trial court wrongly restricted the bias and credibility cross of prosecution expert William Barr. The court ruled that counsel had no good faith basis for this cross, but a good faith basis only requires some reasonable basis in fact for believing the truth of the questions. Of course, the Times article here did provide that good faith basis, and there was really no dispute here.
The Times article was never produced, was it? It was never produced for the court?
The article wasn't produced. Counsel referenced it. The article wasn't produced, and maybe the better practice would have been to produce the article, but there's no legal obligation that counsel had to actually produce the article. And we've cited the two cases in our reply brief that indicate that even hearsay representations and genuine representations on the record about the truth of the questions can suffice. But there was really no dispute that he had also, Barr had also testified well, first of all, that he had made these statements, professing to feeling rather lucky to have worked at the Manhattan DA's office on a number of murder cases, including some that have received coverage in local newspapers, nor is there any dispute that Barr had actually testified in these diverse, not guilty by reason of insanity cases, and that his testimony followed a predictable pattern in those cases. That the defendant.
But isn't your argument sort of overblown? Wasn't the defendant permitted to challenge credibility with respect to the fact that he's not board certified? Substantial, he does 80% of his work, I think, for prosecutors. The monies he was receiving from the DA's office, you were permitted to do that. So overall, wasn't that sufficient?
Well, that wasn't sufficient. Actually, we were entitled to go much further. And the reason why it was important for us to be able to go much further, particularly into the facts of the cases that he had testified in, to establish actually that he had testified, that he'd given this sort of canned testimony in other cases, it was important to be able to show the jury that there are three specific examples of Barr testifying that the defendants were making up their mental illness and they were purely acting out of rage, which is exactly the testimony that he was giving in this case. And now, to Your Honor's point, defense counsel did try to ask about the underlying facts of the Renato Sebra case. That was a case where Barr testified that Renato Sebra had been feigning his mental illness or had been exaggerating his symptoms. But 20 experts had testified that actually he was in the throes of mental illness when he had actually engaged in the underlying conduct in that case. Barr also testified.
There was much more you could have asked, and it's important because this is a defendant who is facing and ultimately received 50 years, could have faced more. But were you not able to make an argument to show that this guy is pro-prosecution and he's biased toward the prosecution? I mean, making that argument doesn't necessarily mean that the jury is going to ignore what he says, even though you make the argument that he's pro-prosecution.
Absolutely. I mean, counsel was allowed to ask, have you testified for the prosecution? And in some respects, logically, when a jury is seeing that an expert is testifying for the prosecution, they recognize that they are testifying on behalf of and may have some orientation to the prosecution, but that's not enough. Counsel should have been allowed to go much further. For example, counsel should have been allowed to ask about the Goldstein case. That was a case where, again, Barr said that the defendant was exaggerating his mental health his mental health conditions, and that he just had ADHD. But in that case, Barr had
I think you're kind of conflating issues. On the one hand, you were trying to show bias. You were trying to show that Dr. Barr had testified for the prosecution more times than he had testified for the defense. you were allowed, I thought, to question as to the amount of money that he charged the district attorney's office as opposed to the amount of money he charged defense. Those types of questions.
Those types of questions are absolutely helpful, but going to the heart.
And so in terms of the heart, the defense was also allowed to question Dr. Barr as to his methodology, which was more important, was it not?
I think, well, the court actually restricted that cross.
As to his methodology?
As to his methodology, the court restricted that cross, absolutely. And I think, you know, and this is a good example of this, you know, if defense counsel had been able to cross about prior cases, different and diverse cases where Barr is testifying for the prosecution, not only stating that he loves, you know, that he finds himself lucky to be testifying for the Manhattan DA's office, but the specific examples of cases in which he had done that, and also the specific examples in those cases that had rebutted the testimony that he had given, we would be in a completely different, you know, a different terrain. And I think the harm, I think, and I think that's what you're going to, Your Honor, is the harm. You know,
well, not only the harm, but I mean, there are differences. You know, you wanted to question Dr. Barr as to his findings in one case as opposed to his findings in another case, but each case is different in terms of what is presented.
Yes.
So I think that wasn't that the basis of the court's decision in terms of limiting, as you say, limiting or not allowing Dr. Barr to testify as to one case over another?
No, Your Honor, that was not the basis for the court's ruling. The only basis for the court's ruling was that defense counsel had no, quote, good faith basis to challenge his professional ethics. And, you know, as we've argued, the New York Times article 100% gave, you know, that good faith basis, 100% provided the basis, in fact, for defense counsel's questions. That was the only basis for the court's ruling. But also to Your Honor's point, I think what Your Honor's getting to is, well, can we ultimately believe Barr's testimony if counsel had been able to cross-examine him, you know, about these things? And I think that that's an issue that goes to weight. That doesn't go to the admissibility of, that doesn't go to, you know, whether or not counsel should have been allowed to cross-examine.
I didn't see anything in the record that the defense was precluded from questioning Dr. Barr as to his methodology and how he came to his determination or his diagnosis of the defendant.
And well, the way that counsel wanted to do that, though, was to cross-examine about these specific cases, right?
Right, but my point was that's the way he wanted to do it,
right.
But he wasn't precluded from actually inquiring as to the methodology. It's just that the way in which he wanted to do it, the court found not to be proper. But that doesn't mean that he was precluded entirely from pursuing that line of questioning.
Well, and to be clear, just to be clear, the court only ruled that there was no good faith basis. The court didn't actually say that the questions you were asking are not proper. The court didn't actually say you're not allowed to challenge his.
Right. So defense at that point in time should just have come up with another avenue in terms of how to elicit that testimony.
But I think, but
the question is whether or not the avenue that the defense counsel used was proper or improper, should have been limited or not whether under the circumstances they should come up with another avenue.
Right, exactly. And it was proper because it is entirely proper to cross-examine an expert regarding his opinions in other cases, particularly his opinions in other cases that are actually rebutted. I was pointing to the example of you know, Andrew Goldstein before, where the expert testified that Andrew Goldstein was just making up his mental illness. But then defense counsel in that case asked Barr whether or not he had actually even reviewed Goldstein's medical records, and Barr testified, no, I hadn't. And those medical records actually showed extensive diagnoses of
I mean, this is the very psychiatrist who, and he wasn't even a forensic psychiatrist, but who was being relied on very heavily to establish these issues.
He was being relied on heavily.
Arguably the most important person to be able to cross.
It was the most important to be able to cross, and we can look at the way in which the prosecution relied on Barr's testimony in summation to establish one very critical point here, and this was the only witness who testified to that, which is, were there other reasons for appellant's behavior? It was only Barr. Barr was the only witness at this trial that said that, you know, it wasn't mental illness. It was that he was, again, he was making up that he was mentally ill, and also that he was acting out of rage because he was angry at his girlfriend, and that he was angry about his lot in life. That was the pivotal testimony, the pivotal testimony in this case that, again, the prosecution relied on, and that rebutted and undermined the not guilty by reason of insanity defense. You know, again, he was really the linchpin of the people's case that appellant was faking his mental illness. You know, again, he was the only one who came up with this alternate theory that appellant was acting out of rage because he was angry at his girlfriend. You know, if we were to, so in thinking about harm, if you were to realize the full damaging potential of this cross, Barr would have been completely discredited, and the jury would have rejected his testimony, and it would have found—
Well, that would have remained to be seen whether that would have happened.
But it wasn't. The court was wrong to have precluded this line of cross altogether. Whether or not the jury believed him, whether or not the jury discredited Barr, was ultimately a question for the jury to decide. But it wasn't for the court to preclude this line of cross altogether solely on the basis, again, as the court ruled, that he had no good faith basis. I will return on rebuttal.
Thank you.
Good afternoon, Your Honors. Dana Poole for the people. What we're dealing with here is not the cross-examination that appellate counsel would have come up with. What we're facing here is what trial counsel was actually asking the witness and what was presented to the trial judge. And what was presented in that instance was conclusory and accusatory questions that were vague.
So why wouldn't it have been relevant to ask as to other cases such as Andrew Goldstein?
Well, we're not sure in this case because counsel never made that argument. Counsel may well have wanted to ask about that case, but the questions that he asked were things like, isn't it your standard theme that a person didn't act out of mental illness but acted out of rage? That's what Justice Whitner—
So he did not point to specific cases? Is that what you're saying?
That's what I'm saying, Your Honor. So what the judge was reacting to was these sorts of questions, and she said, you have no good faith basis for it. And at that point, defense counsel didn't come and say, I have this article in which Barr is quoted.
Yeah, but why don't you address the article? Why wouldn't the article, even if it wasn't produced in court, why wouldn't that be a good faith basis with respect to something to present to the jury?
Right. Our position is not that it could not have provided a good faith basis for questioning. Our point is that's not what was happening in front of the jury. What was happening in front of the jury was these very argumentative and conclusory questions where counsel was trying to make his argument through questioning the witness rather than eliciting facts, rather than laying a foundation.
Counsel, was the problem that the questions were argumentative, or was the problem that the court said that the defendant didn't have a good faith basis?
The way that the questions were structured, there was no apparent good faith basis for accusatory questions. So that's what she was calling counsel out on.
You seem to be putting a lot of kid gloves on cross-examination here. Good faith basis. I mean, they're not attempting to introduce collateral evidence on a character matter or something. They're probing bias.
And we're not arguing that counsel should not have been allowed to go there. And when the questions were properly presented, he was absolutely allowed to go there. But what the judge was reacting to was things like, you know, he's asking, when you're working for the prosecutors, is there anything other than monetary gain that prompts your testimony? Well, that's, you know,
that was an open-ended question.
But it's assuming that monetary gain is his reason for testifying in the first place.
He's there to answer, he can answer the question however he wants.
Right, but again, what they're saying is, what they're doing is making an argument. They're not laying a foundation for, these are the facts of another case. You testified in that case. For instance, what was your methodology?
It doesn't only have to be those kinds of questions, because how much a person makes may influence them also to want to testify for a particular agency or organization or anything else. And to me, that question you just used, to me, you know, it's an open-ended, he can answer it if he wants to. May not be so flattering to him, but he can answer it. I mean, after all, he is a key witness in this case. That question is nothing. You get argument. You get summation. You can put that into perspective, and your witness should be able to answer it. Absolutely, he could bury somebody with a proper answer to that question.
Well, he was allowed to answer, he was allowed to ask and get answers to how much money he was making. Didn't you sit in the courtroom all day and you collected many thousands of dollars just by sitting and listening to other experts' testimony? Questions like that were absolutely allowed. He was allowed to ask those questions. What he wasn't allowed to do was to ask argumentative and conclusory questions that had no apparent basis on their face. And when at a sidebar, when all he said was like, well, he talks to the press and read the article, he's not laying out for the judge who is trying to figure out what he's trying to do. All she's hearing is argument.
When counsel says read the article, what happens then? The issue is just dropped?
Then, yes. He sort of runs off in a snit and drops the issue rather than laying out for the judge what it is that he wants to ask about. And Justice Whitner in these instances was often working with the attorneys saying, like, you can't ask a question in that way, and then if it were reframed, it would be fine.
I thought the read the article came from his wanting to question Dr. Barr as to whether he was quote unquote a publicity hound, whether he sought out the media, questions like that, such as that.
There were those kinds of questions, but what the article was not clear. Also, it was not clear from defense counsel's questions that, he was saying, well, you've actually told a reporter X, Y, and Z. That would be a very different scenario. That's the way that this article could have served as a good faith basis.
Well, then I don't know that he would have been able to do that from something that wasn't in evidence, perhaps. I'm not sure.
Well, he could have asked, haven't you said? Now,
yes.
he may have been stuck with the answer. He may not have been able to collaterally impeach the answer.
I'm still not understanding the Goldstein issue. Why was he precluded from answering questions as to that particular case and his findings in that particular case?
Because that's not what counsel was doing. Counsel wasn't asking those kinds of questions. He was asking these very conclusory sort of questions and not specifically comparing case to case. He was simply using, apparently from this article, the reporter's conclusion that he had sort of come up with this theme that he presented. But again, counsel was not laying any sort of foundation for why Goldstein was relevant to this case. And that's shown by the fact that it's not in the record. At no point in the record does counsel sort of explain where it is that he's trying to go with this path of cross-examination. Unless you have any other questions, we ask that you affirm the conviction. Thank you.
I've laid out in page 7, footnote 2, the specific questions that counsel asked to Barr that the court sustained. Counsel asked whether Barr enjoyed the publicity and had reasons for testifying other than monetary gains and had been in papers as a result. Counsel also asked Barr whether in these cases which he testified for the prosecutor where the defense has claimed mental illness, whether he gave the standard theme testimony the defendant was not acting out of mental illness but out of rage. Then counsel asked, was that the standard theme testimony that you gave in Mr. Seba's case? And then counsel asked whether you testified in any homicide case that the killing was caused by mental illness. And then he asked whether, Barr had testified that people are mentally ill, but not as mentally ill as believed. And then counsel also asked whether he had ever testified for the defense in a case where a pedophile was seeking to be released and the prosecution's office didn't want him to be released. The court sustained his objections to every single one of these specific questions. So I dispute my adversary's characterization of defense counsel's.
Well, at least as to the last question, there was no allegation of pedophilia in this particular case. But, in terms of the other questions, did the court give it a ruling or statement why they were sustaining those?
The court just said sustained. And again, I'd like to highlight again, the only basis for the court's ruling in this case was that there was no good faith basis for counsel to ask these questions. And my adversary, it seems to me, I might be mistaken, but has conceded that they're not disputing that there was a good faith basis for these arguments. If that's the issue, then the issue is pretty narrow for this court to decide. Counsel had a good faith basis. Well, it might have been a better practice for him to have presented the New York Times article. He pointed to the article, which itself was a good faith basis, and at that point, it was for the court to decide, well, you know, you can ask these questions about bias. Maybe you can present to me the questions that you want to ask to this witness, and then we can decide whether or not they're probative, whether or not they're harassing, whether or not they're collateral, or whether or not they're irrelevant. That would have been the better practice, but instead the court precluded the questioning outright. And that's really the problem here. Again, particularly given how important he was to the people's case, precluding this question completely undermined the defense. And for these reasons, we ask that the court reverse the conviction and order a new trial. Thank you.
Thank you. Thank you both. Klingerman versus Ali.
Good afternoon, Your Honors. May it please the Court. I'm Robert Heim, and I represent the defendants' appellants, the Silk Road entities. Our contention is that the court below erred when it refused or denied the motion of the Silk Road entities to dismiss the complaint based on lack of personal jurisdiction over these companies, and also that the court erred when refusing to grant our motion to dismiss based on forum nonconvenience. Turning first to the personal jurisdiction point, the lower court erred when it held that there were sufficient contacts between the Silk Road entities and New York State to warrant a finding of personal jurisdiction. The Silk Road entities are all non-U.S. entities, and their sole shareholder and director since January 2013 is Kamaluddin Talipov, who is a resident of Uzbekistan. Neither the Silk Road entities nor Mr. Talipov have ever made...
So there's a purported sale, I guess, in 2012. Were there any interactions between Ali and the companies over the years after that?
There were some limited interactions.
Limited? So in other words, did monies come in to pay for Mr. Ali's personal expenses, rent, tuition, et cetera?
There was interactions and there was money that came in. However, the standard here and what the lower court based its decision on was that Mr. Ali was an alter ego of the Silk Road entities. And under the baby fat case from this court, the plaintiff has to show that Mr. Ali dominated and controlled the Silk Road entities in order for them to be held to be alter egos. We have in the record evidence from the Cayman Islands Public Register of Companies showing that Mr. Ali left his association with the companies as a shareholder.
Then why would, if that's the case, why, just logically, why would a company that has no connection with Ali continue to pay for his personal expenses?
Well, both the affidavits from Mr. Ali and Mr. Talipov indicate that the money that Mr. Ali received after January 2013 was for prior services that were rendered to the companies.
Would it be fair to say that maybe the affidavits were self-serving?
Well, I think that any affidavit is probably going.
And wouldn't we need discovery on these issues? I mean, you may very well be correct, but isn't this stuff that we go through discovery to really determine whether or not there's an alter ego relationship here?
Well, with regards to the jurisdictional question, perhaps there might be discovery on whether personal jurisdiction is present, but that's not what the lower court did. The lower court didn't give any sort of consideration as to the context of the Silk Road entities and the relationship with Mr. Ali. It just accepted the argument that Mr. Ali was the alter ego of these companies without any sort of analysis or consideration of that point.
Sir, did you ask for jurisdictional discovery?
No, because it's the plaintiff's burden to prove that they have personal jurisdiction over the Silk Road entities.
Did you ask for a hearing on the issue, given the variance between their affidavits and yours on the alter ego point?
No, because again, that's the plaintiff's burden to be able to establish that Mr. Ali is controlling those entities and that he is the person that's in control. So it's not our burden as the defendants to...
So really what it just boils down to is whether their jurisdictional allegations vis-a-vis alter ego are sufficient.
Oh, yes, in a way, but it also boils down to whether the court gave adequate consideration to our arguments regarding the lack of contact with New York State, the lack of purposeful availment.
Well, were New York correspondent bank accounts, were they used to transfer monies in and out?
There were some wire transfers that went through the New York bank accounts, but
Would that maybe be another alternative basis to show the jurisdiction?
well, no, not in this case, because the case law on that point is that in addition to having gone through the New York correspondent bank accounts, there also has to be that element of purposeful availment by the companies. It can't be just like a happenstance.
So the companies were transferring monies through New York banks to pay for Mr. Ali's personal expenses. Would that qualify, would that meet that standard?
No, not in our view, because number one, we contest that it was Mr. Ali's personal expenses that were being paid by corporate assets versus past payment for past services. But more
Past services, as Justice Singh had mentioned previously, the transfers were to the school for Mr. Ali's children. That was, again, for past services?
yes, all of the compensation that Mr. Ali received after January 2013 was for past services that he had rendered to the Silk Road entities.
Including the rent or whatever for the lease payment, the lease payments for the one side?
Yes, the lease payments and the school tuition.
Are there any, documents to verify that? I mean, because you're saying the amount for the rent, the amount for the school, the amount for this, all total things that were pending, that he was owed, that he didn't get. There's something that verifies that?
Yes, there's purchase and sale agreements demonstrating that Mr. Talipov took over as the shareholder and officer of these companies, and there's also agreements in place. Many of those documents are in Mongolia or Uzbekistan, and that's the other challenge of this case and why we feel it's appropriate for this case to be heard in
Well, I think my colleague
forum.
was getting at not so much that, but for example, 1099s, things, IRS documents showing in fact that these are payments for past services and not some ongoing and continuing relationship between the companies. Any of that?
Yes, there would be contracts for that. I don't know if there's
Were 1099s given, for example?
I'm not aware of any sort of 1099s because these were offshore entities. Also, during the relevant time period, Mr. Ali himself was a resident of Mongolia, and he just traveled to New York sporadically for purposes not related to business.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Gonzalo Zabayos for Respondent Matthew Klingerman. The first thing I'd like to address is this idea that the Court simply accepted the argument. The Court didn't simply accept the argument. The Court found that the allegations of alter ego and the allegations of personal jurisdiction over the defendants in this case were sufficient.
Well, sufficient just for jurisdictional purposes.
For jurisdictional purposes.
Because presumably through discovery, the defendants will have an opportunity, if this case continues in New York, to show, in fact, that there was no alter ego, correct?
Correct, Your Honors. And in opposition to those findings, they rely almost exclusively on this declaration of Mr. Talipov. And Mr. Talipov's statement, as we noted in our papers, is riddled with contradictions and fabrications. But what's even more remarkable, well, before I get to this point, let's take a look at the exhibits that he attaches and when these filings were made. This is on record page 583. The notification of resignation of Mr. Ali was filed on June 18th, 2017, well after Mr. Klingerman had been appointed and this dispute was afoot. The effective date of the resignation is 25 January 2013, which is just a few days, 5 days before Goodwill's investment. I find that timing to be extremely suspect and extremely convenient to your point of it being self-serving. The affidavit itself contains false statements that are critical. We learned yesterday, and I informed Mr. Heim about this yesterday, in a routine check of the corporate registry in the Cayman Islands, that Defendant Eurasia Capital Limited and Silk Road Management Limited have been stricken from the corporate registry in the Cayman Islands.
Well, counsel, is that something that's in the record now or something?
It's in the public record, and the court can certainly take judicial notice of it. But for the purposes of this argument, it goes to the credibility of Mr. Talipov. Mr. Talipov is saying, I am the sole director and sole shareholder of defendants Eurasia Capital, ECL, and Silk Road Management, SRML. This is paragraph 1, page 95 of the record. That's a false statement. He can't be the director of a company that doesn't exist. He can't be the sole shareholder of a company that doesn't exist. In paragraph 6, he states ECL is a company that is duly organized and existing under the laws of the Cayman Islands. He says SRMRL is a company duly organized and existing under the laws of the Cayman Islands. Those are both false statements again. Those companies do not exist. Now, if these companies had been stricken before we filed our lawsuit, we couldn't have sued them. We would have had to reinstate them in order to sue them because they don't exist. You'd be suing the equivalent of suing a dead person or a non-existent company. And here we have a statement from the guy who purports to be the owner of these companies. Either he doesn't know that it's been stricken from the corporate registry, which raises a very serious question about whether his allegations that he's now the sole director and sole shareholder of these companies is true, or he's lying. Either one of those outcomes, I think, is fatal to the credibility of everything contained in this statement. So I don't believe that the court should give any weight to the Talipov Declaration, and I think that what we would like to do is have this remanded as soon as possible. Oh, and I should note that Silk Road Finance Limited, 31, was stricken from the corporate register on 31st of August 2021, which means that when this affidavit was submitted in support of this appeal, which was filed in September of 2022, that statement was false as to 3 of the 4 defendants. The 4th defendant, ECML, in this very affirmation acknowledges that ECML was dissolved in Mongolia. I don't see any evidence in here that that's still a going concern. So there's a real question here as to whether Mr. Heim has any clients. Does he have any authority to appear on behalf of these clients? Do these clients have any standing to even appear before this court? And I'll acknowledge that's perhaps an issue for the Supreme Court to address in motion practice, but we'd like to get this back before them as soon as possible to resolve this issue, because I think there's a really serious problem with 3 non-defunct entities filing an appeal before this court. Now, with respect to the payments made to Mr. Ali and the use of the correspondent banking system, I mean, we have no fewer than 45 wire transfer orders from Mr. Ali involving the Silk Road entities, the Silk Road defendants, instructing the bank in New York, noting that's in New York, in some cases noting that he's the beneficiary, that he resides in New York, contradicting their statements that he was never present in New York, showing intentional, absolutely intentional use of the correspondent bank system. So any notion that the use of the correspondent bank systems for what we say to us to perpetrate this fraud, that it was accidental or incidental, should not be given too much consideration. And finally, I'd note that Mr. Klingerman's complaint in this case is supported by hundreds of pages of email correspondence, bank statements, forensic analyses. Every allegation is supported by a documentary fact showing that he did an extensive and thorough analysis of where these monies came from, where they went, where Mr. Ali was residing, where he was writing from when he says, please meet me, I'm in New York. In contrast to that, we have, opposing that, we have a frankly extremely suspect affidavit that essentially says none of that's true. And that is contradicted by the statements of other witnesses in this case, of their own witnesses in this case. So again, I would submit that there's very little to support their argument that the trial court should be reversed on this issue. Unless the judges have any further questions, I have nothing more to add.
Thank you.
Thank you. Well, our first point in response is that the court should not consider anything related to documents that are not in the record. As opposing counsel had indicated, he just brought this to my attention yesterday, and these documents have not been authenticated. We haven't had a chance to talk to local Cayman counsel regarding the effectiveness of these documents or whether the companies can be reinstated. So we submit that that's not appropriate for the court to consider since it's not part of the record. Second, I'd like to address Mr. Klingerman's so-called evidence for why Mr. Ali is an alter ego of the companies. If you look at record page 239, you'll see that Mr. Klingerman's evidence for that is solely related to printouts that he made in May and July 2012, which is about 6 months before January 2013 when Mr. Ali left. So Mr. Klingerman's evidence for the fact that in his allegation that Mr. Ali was still associated with the Silk Road entities is outdated documents from about 6 or 7 months prior to the time that Mr. Ali left the Silk Road entities. And Mr. Klingerman's affidavits, which rely on those very same exhibits, are circular. So there's really no independent evidence that Mr. Klingerman puts into the record regarding this alter ego theory.
Sir, is the plaintiff in a sort of a difficult spot here? They commence the action. They obviously have to do so within a certain statute of limitations. They have whatever information they have that tends to support their alter ego theory. So they put it forward, and now they either have given sufficient allegations to support an alter ego theory of jurisdiction, or they haven't. But I thought I heard your friend say that essentially this is alter ego for the purpose of jurisdiction only, and that it may come out in discovery proper during the case that in fact they weren't alter egos, and therefore the consequences that would flow liability-wise wouldn't attach to your clients.
That's correct, but in the initial instance, the court first has to address whether there's personal jurisdiction over the Silk Road entities, and Mr. Klingerman's argument is undercut by the fact that he previously commenced litigation in Bermuda against these same defendants for the same claims. So Bermuda is clearly the correct jurisdiction to hear this dispute. That's where the M3 fund is formed. That's where Mr. Klingerman was appointed.
Are you now arguing FNC? I mean, is that what you're arguing?
Yes, that goes to our...
So let me ask you about that. The case is going forward with Ali in New York, correct?
That's correct.
And if in fact he is an alter ego of the Silk Road entities, what's the burden on the companies to litigate in New York?
Well, the companies and Mr. Ali are two separate entities. The company's new director and shareholder is Mr. Talipov, who's in Uzbekistan.
But they're not, because according to your adversary, there are over 40 transactions, wire transfers, et cetera. So it's not, the entire record really doesn't support that argument.
Well, I think you have to look at it in terms of where the evidence is going to be for those alleged transactions. It's going to be in Mongolia with respect to where these wires originated from, who is aware from the companies that they were being sent out. Other than the fact that Mr. Ali received this money in New York, there's no other connection to New York. All of the substance and the weight of the transactions occurred in Bermuda and Mongolia.
Okay.
Thank you.
Thank you both.
This off. I just usually put the pencils back.
Put everything back?
I just put the pencils back. It's virtual. It's virtual? All right, thank you. Have a good night, everybody.
We'll hear soon. Collect the waters.
We could turn off the mics on.